Welcome everyone to the House Committee on Judiciary and Hawaiian Affairs. It is Wednesday, April 1st, no fooling. Right. That helps. Laughter really does help, you know, appreciate it. This place gets so serious and everyone gets grumpy and salty and thank you for that. Yes, it is Wednesday, April 1st, 2026. It's 2 p.m. here in conference room 325. My name is David Tarnas. I'm chair of the committee. Our wonderful vice chair, Regina Poipoi, is here. And our inveterate member, always here on time, Representative Shimizu. Thank you very much. And other members are watching from their offices and will join us presently. We're here for the purposes of hearing numerous bills, but before I get started, just to say, if you're going to testify, could you keep your testimony to about 2 minutes? I'll ask you to summarize at that point. If you're testifying by Zoom, please keep your microphone off and your camera off until you testify, and turn it on for your testimony and turn it off afterward. If you have issues or technical issues, it's okay to use the message function, the chat function, to contact our IT staff, and they're super smart and they can help if at all possible. And if you get cut off for some reason on your end, try to rejoin and I'll let you finish if time permits when you rejoin. Please don't use any copyrighted images or trademarked images on your background for your Zoom call, because that bumps us off of YouTube and we don't want that. When you come up to testify, please use the rostrum here and just speak normally. The microphones in the ceiling will pick it up, and so you should be just fine. But microphones are very sensitive, so they will also pick up side conversations between your neighbor where you're seated. So if you could keep those conversations to a minimum, that would be great. And as usual, you know, conduct yourself with aloha, please. It's okay to disagree, but let's not be disagreeable, please. I think it really doesn't help anybody if we get grumpy with each other. With that, let's go ahead and get started. Senate Bill 3322, Senate Draft 2, House Draft 1, relating to law enforcement. This measure by July 1st, 2027 requires each law enforcement agency operating in the state to establish and publicly post a written policy regarding the use of facial coverings, visibility of badges, and conspicuous marking of law enforcement vehicles and civil immigration enforcement, including procedures governing a law enforcement officer's authority to make an inquiry into a person's civil immigration status. The bill prohibits law enforcement officers from initiating or prolonging a stop, detention, or arrest to determine a person's civil immigration status, with certain exemptions for reasonable suspicion. It establishes as a policy of the Department of Law Enforcement that civil immigration activity involving state or county participation or facility shall only proceed under certain conditions. It also establishes criminal offenses for improper facial coverings and lack of visible identification and unauthorized civil immigration interrogation, arrest, or detention. First up, we have the Office of the Public Defender. Ms. Haley Chang, welcome.
Good afternoon, Chair Tarnas, Vice Chair Poipoi, and committee members. Haley Chang from the Office of the Public Defender. Our office stands in strong support of this measure. As we have been testifying all session long on measures similar to this one, we believe transparency in law enforcement is critical for our community members. What is going on nationally is frightening and creates fear and skepticism amongst our community with our local law enforcement, and I think this measure addresses that. Transparency, visibility, all of those things that this bill addresses are critical. We also want to say that we stand in strong support of the prevention of prolonged stops and improper status inquiries for people beyond what should be established by reasonable suspicion. So I will be available for any questions. Thank you.
Thank you very much. Liza Ryan Gill, Hawaii Coalition for Immigrant Rights.
Hello, Chair, Vice Chair, members of the committee. Liza Ryan Gill with Hawaii Coalition for Immigrant Rights. We represent about 30 immigrant-serving organizations across the Pai'aina. And I just want to share a few very recent examples that help bring some context as why we want to see bills like this going forward. Just this morning, I was running at Ala Moana Beach Park, and I saw a white truck. Fortunately, it had markings on the side. It was U.S. Customs and Border Protection. And I was like, oh, I've never seen Border Patrol in a truck that looks like that. And so I took a quick picture and then I referenced it and I was like, oh, they're actually just doing customs work and everything. Now that's me who grew up in a border town who saw Border Patrol every single day. Recently, we had our National Guard, Hawaii State National Guard, in Humvees rolling up through Kalihi, and we were getting multiple questions from the community asking, who is this? How do we know who they are? Like, what should we be doing in this context? And even since then, we've had the Kona Low, and we have numerous farmers, Southeast Asian farmers working out in Wailua, green card holders that are afraid to have folks come to their doors, come out and receive help because they're concerned because are there agents here? It's a really, really tough time. And the more transparency that we can provide as to our local police and our local law enforcement, they're identifiable, you see their face, maybe you know their cousin, you can see their ID, you know who that person is, and you also have the background to know that they are just there to do their job. They are separate from the federal government. The federal government is allowed to do their work, but when they are here, they will look like something different. And I think that is really, really important. We forget this is a high information context we are in here. A lot of people exist in very low information context, so they are not necessarily even getting an alert to tell them that the dam might be failing, much less being able to know what all these different agencies look like. And then you add on top of that the fact that Department of Homeland Security has been pulling in lots of different federal agencies to also do civil immigration work. It's really important that we make it very, very clear. Everybody has a job to do. They should do that job, but we're not doing each other's job, and we should be clear and be able to see who it is who's doing that so that we can maintain our own personal trust regardless of what the federal government is doing. Mahalo.
Thank you very much. Next, Kat Brady, in support, not present. Next, Chris Caulfield, Imua Alliance, in support, not present. Next, Mandy Fernandez, ACLU.
Alohi, Chair Tarnas, Vice Chair Poipoi, and committee members. My name is Salma Rizvi. I'm here and standing for Mandy Fernandez. I'm the Executive Director of the American Civil Liberties Union of Hawaii, representing more than 4,000 card-carrying members in our state. We stand in strong written support of SB 3322. We also note that one of the clearest warning signs of authoritarianism's rise is anonymous law enforcement. Across the continent and here in Hawaii, federal immigration enforcement has been conducted by agents who are masked, in plain clothes, unmarked vehicles, and without visible identification. And some masked agents have been filmed using lethal force both against U.S. protesters and against immigrants. Over the past year, federal immigration authorities with masks on their face have detained more than 3,800 children. When law enforcement obscures its identity, especially in life or death encounters or interactions with children, fear becomes indistinguishable from terror. And the FBI has warned that criminals are exploiting ICE's lack of identification to impersonate officers and commit robbery, kidnapping, and sexual assaults. Accordingly, the practice of masking law enforcement traumatizes our residents, erodes trust in law enforcement, and undermines public safety. This bill affirms that here in Hawaii, authoritarian-like enforcement tactics that hide identity, erode accountability, and endanger the public will not be normalized. Furthermore, the U.S. Constitution's Fourth Amendment and the Hawaii State's Constitution, Article 1, Section 7, prohibits unlawful searches, including prolonged stops by law enforcement. Yet we are seeing dangerous constitutional erosions by police, particularly following U.S. Supreme Court Justice Kavanaugh's opinion in which he allowed race to be a factor in the reasonable suspicion analysis. We do not want this racism occurring here. We need to pass laws so Black and brown bodies are not unnecessarily targeted and harassed due to their skin color. Accordingly, this bill is not just about immigration. It is more so about protecting community safety, psychological welfare, our local culture, the rule of law, and most importantly, due process. While we stand in support of SB 3322, we believe HB 1886 remains the strongest vehicle for pushing forward these protections. Still, we urge you to consider passing either measure. Thank you for your time.
Thank you very much. Next, Abby Simmons on Zoom. Could you please unmute yourself, Abby?
My apologies.
Thank you.
Thank you, Chair. and aloha to Vice Chair Poipoi and members of the committee, Abby Simmons, Stonewall Caucus, Democratic Party of Hawaii, in strong support of the bill. Just a few comments, generally stand on our written testimony, but I think that we all remember what happened to Alex Pretty and Renee Good, and we cannot normalize that in our society of laws, of rules and laws. And having masked agents commit crimes makes it a lot harder to hold them accountable in the court of law. So it's very important that we make sure that law enforcement agents or any agency of the federal government follows the law, clearly identifies themselves with their badge, and does not wear a mask. Further, we're really concerned about the upcoming election and masked agents appearing at polling stations. That should be a concern for all of us, regardless of party affiliation. And so it is very important that we move this bill forward, and I ask for your leadership to support this bill. Mahalo.
Thank you very much. Next, Nate Hicks, Hawaii Public Health Institute. Welcome, sir.
Aloha Chair, Vice Chair, members of the committee, Nate Hicks with Hawaii Public Health Institute in support. Appreciate the opportunity to testify on this bill. We've seen a lot of the damage that's been done to many communities around the nation. I'm from Minnesota originally, and I have a lot of friends and family who've been traumatized by the situation up there. And so I just want to say that taking any step we can to make a more safe experience for all of our residents, not just our immigrants, but for our citizens. I know folks who have avoided certain areas who are born in America, are not the target group, but want to make sure that they're not put in a dangerous situation. And so making it safe for everybody, I think, is a win across the board. Mahalo.
Thank you very much, Mr. Hicks. Next, Tim Pike. In support, not present. Next, Christine Andrews on Zoom.
Aloha, Chair, Vice Chair, members of the committee. I will stand on my written testimony. I just like to reiterate that I am a constitutional observer here on Maui as part of the Apr Maui Coalition, and I do live in fear. When I am home, my curtains are drawn, my doors are locked, because unmasked agents have shot and killed people like me, engaged in our First Amendment rights, and have not been held accountable. They have not even been identified in the state of Minnesota. They are actually suing the federal government for obstruction in the investigation into the murders of Renee Good and Alex Pretty. So making sure that our law enforcement protects our communities and our communities feel safe in depending upon law enforcement to protect them as victims of crime is an important value, I think, that we all can hold dear. So thank you again for supporting this bill, and I'm available for any comments.
Thank you very much. Next, Michael Goloyu on Zoom.
Good afternoon, Mike. Good afternoon, Michael Goloyu Jr., he, him pronouns, President of Pride to Work Hawaii. We stand in strong support of this measure, as so do so many of our fellow citizens, as we saw over this past weekend when we all took to the streets in the largest American protest in U.S. history against these actions that we have seen. ICE is a terrorist organization, and stop. We have seen them terrorize our average people on the side of the roads. They've been kidnapping people, and that is what is called when you take people with you don't have a judicial warrant. They storm people's houses, businesses, taking people from courts, and they do it under the guise with masks over their faces, so we don't know who they are. As my grandma told me growing up, when someone wears a mask and they're doing something they shouldn't be doing. And so take Grandma Martinez at her word. I always did. I trusted her, and I ask you to trust her as well. And pass this bill. We need to keep these armed vigilantes in check and make sure that we know who they are. They need to be able to identify themselves. We need to know that they are actual law enforcement officers, and being able and having their faces uncovered while they're using taxpayer dollars is the minimum we can expect from law enforcement. So we encourage you to pass this bill, protect us all from this fascist administration.
Thank you. Anyone else wishing to testify on this measure? Senate Bill 3322. If not, questions, members? Seeing none, thank you very much. Let's move on to the next measure. Senate Bill 2090, House Draft 1, relating to child custody. This measure allows licensed mental health counselors to be appointed as child custody evaluators. Members, we received 2 testimonies in writing in support. I've not been informed that anyone wants to testify in person. Is anyone here wishing to testify in Senate Bill 2090? Is Office of Hawaiian Affairs on Zoom? No? Okay. Nobody here to testify on that? Okay, let's move on to the next measure. Senate Bill 2108, Senate Draft 1, House Draft 1, relating to jurisdiction. This measure amends the factors the family court is required to consider in deciding whether the court may waive jurisdiction over a minor held for criminal proceedings. It preserves the family court's jurisdiction over a minor transferred for criminal proceedings for subsequent acts that would otherwise be within the family court's jurisdiction. It requires the family court to retain jurisdiction over a minor if the court finds by clear and convincing evidence that the minor was trafficked, sexually abused, or raped by the alleged victim in the case before or during the commission of the alleged offense. First up, we have Office of the Public Defender. Ms. Chang, welcome.
And good afternoon again. The Office of the Public Defender stands in strong support of this measure. As the preamble to the bill indicates, and as we've seen in practice, over 70% of juveniles in the system have suffered emotional or physical abuse, and another 45% have been victims of sexual abuse. Our office has a juvenile division that is devoted to representing juveniles in the criminal system. And of course, I myself have spent a significant time in my career representing juveniles as well. So aside from what the studies can show, I can anecdotally say that this could not be further from the truth. Why this measure is important is it does require the court to consider additional information when we are making a decision to waive someone into adult court, because that's exactly what this procedure is contemplating. When somebody gets waived into adult courts, there is no special treatment. We have juvenile offenders who get committed to OCCC with the adults. There's no special breaks, so they are treated just like adults when they are not. And I think this measure is responsive to the trauma, the abuse that a lot of these children suffer from, and that is something that the court should consider before we put them in the criminal system with 30-year-olds, 40-year-olds, 50-year-olds, and sentence them accordingly. So thank you for the opportunity to comment. I will be available for questions.
Thank you very much. Next, Teresa Komenos, Human Rights for Kids on Zoom.
Good afternoon, Chair Tarnas and members of the committee. Teresa Komenos on behalf of Human Rights for Kids in support of SB 2108. We're here today because this measure would ensure that a child's lived experience is considered by the court before a case can be waived into adult criminal court by adding those additional factors for courts to consider at a waiver hearing that would allow the court to look at a child's full experiences more extensively and in a trauma-informed way before making such an important jurisdictional decision. In addition to the provisions outlined in this measure, we would also encourage the committee to adopt an amendment to ensure that only children 14 years of age or older may be waived into adult court. For one specific section of HRS 57122, Section D, there's no minimum age requirement for a child to be waived into adult court, meaning that 12 and 13-year-old children could be subject to waiver and prosecuted as adults. To put this into context, these are elementary and middle school age children. Several other states have set a minimum age of 14 years old, regardless of the crime charged, before a child may be prosecuted as an adult, even for the most serious offenses. These include states like Utah, New Mexico, North Dakota, Arkansas, Louisiana. There's several others. Additionally, Connecticut, California, and Oregon all have set 15 years as this minimum. So we'd urge the committee to add that necessary language to establish that a child must be 14 years of age or older before being waived into adult court. Research by Human Rights for Kids has shown that nationally more than 70% of children tried as adults experience both physical and emotional abuse prior to their offense, and another 45% experience sexual abuse. The average ACE score for was 6.31 out of 10, and the average onset age of abuse was 6 years old. Further, approximately 30% of the people we surveyed who were tried as adults for crimes they committed as children were trafficking. So this type of trauma impacts a child's brain development, particularly the prefrontal cortex, which means that beyond what we already understand about developing adolescent brains, for kids who've experienced significant trauma in their home community, their brain development has been further impacted in a way that influences behavior and decision making, which it is why it's so important that courts consider this information and ensure that children have a robust evidentiary hearing that evaluates all of these factors before they're prosecuted as an adult. It's for these reasons that we would support this, so thank you so much.
Thank you very much. Anyone else wishing to testify on this measure? If not, questions, members?
Question,
Dr.
Chair.
Mizu.
Public defender, am I able to ask the question? You know thank you for being here, thank you, Chair. The previous testifier just mentioned the age, 14, setting a minimum. I guess I'm trying to wrap my brain around that, if that's a better provision than just no age limit. Would you comment on that?
I would absolutely support having a limit or a minimum age for someone could be considered waived into adult court. The reason is when we are talking about below 14, we're talking about 13-year-olds, 12-year-olds, 11-year-olds, and we have juveniles that have been arrested and brought into the system, at least our office can say as young as 8 years old.
Tried as an adult?
Not necessarily tried as an adult, but these are the individuals that could potentially be tried as an adult because they are brought into the criminal system. And again, I think the testifier after me, who maybe is more of an expert in this area, could talk about, I mean, there's a lot of scientific research that talks about the development of the brain, maturity levels, etc. And really, like we said, when you are brought into an adult court, the response to you and your rehabilitation and how you're treated is drastically different than what is available in juvenile court. And I could go into the details of that, but it's just very different.
So I'm hearing that it is a benefit to set a minimum age.
Yes, our position would be yes.
Thank you.
Thank you.
Other questions, members?
Sure.
Yes.
Yeah, thank you for being here today. So, and I am in support of this, but I'm thinking along the lines about, a child commits something pretty horrific, and there is a background to the effect of the trauma and the life that the child has lived that led to it. But where is there a line drawn to the point of the seriousness of the crime versus, regardless of the trauma and what the child had gone through, there's a certain point where maybe they know right from wrong, but so when will they be held accountable, I guess, to what they had committed?
And thank you for the question. I think what's important is what this measure outlines is additional factors for the court to consider, not the only factor. Currently, there are multiple factors as outlined in the measure, and one of them is the seriousness of the offense. Another is the impact to the victims. Another is if physical or bodily harm was caused. So the court currently has the ability and must, as mandated by our statute, consider those in making a decision to waive. What this measure does, though, is add additional requirements for the court to consider, but again, it's just a factor. It doesn't dictate the outcome, with the exception that if there's clear and convincing evidence that the juvenile was a victim of the alleged victim in the crime, then they shall not be waived. But short of that, it is just one factor that the court should consider, and it's a balancing test, as it always is when the court is required to consider multiple factors in a decision making.
And Chair, one follow-up?
Of course.
And so as, children are impressionable at young ages, so do you find, or has there been occurrences, the child now tried as an adult gets into an adult environment in the prison system itself. What kind of adverse effects is that for a child that's still developing, of sorts?
Right, and I think you can, sort of make the logical conclusion of adult facilities are not meant to deal with juveniles. And in fact, our adult system is not meant to deal with juveniles. For example, even if you get, you know, an adult sentence and you're not given prison time, if you're put on probation, that will be with the adult probation team. And that is not set up or designed to address juvenile needs. That is our position. The resources, the energy, the personnel who works with our juvenile team, we have a whole branch that's devoted to the juveniles. They have their own specialty courts, they have their own judges, they have their own resources, their own treatment programs. All of that is not carried over into the adult system. So there are far-reaching consequences, and what this measure does is just appropriately consider you know, where this juvenile came from, what drew him in or her into the system, and that as this bill correctly recognizes as well, it's adult influences, and that can be significant more times than not.
Again, thank you for your expertise in the field.
No,
for
thank
your time.
you. Thank you for the opportunity.
Yes, thank you, Chair.
Thank you. Okay, if there's no other questions, we'll move on to the next measure. Senate Bill 2325 relating to juvenile offenders. This measure authorizes a court to modify sentences imposed on juvenile offenders if certain conditions are met and the court finds that, after considering certain factors, the defendant is not a danger to the safety of any person or the community, and the modification is in the interest of justice. The measure establishes procedures, provides for hearings and representation by counsel, and authorizes appellate review. First up, we have Office of Hawaiian Affairs in support. Not present. Next, we have Office of the Public Defender in support. Grateful you're here, Ms.
Yeah, good afternoon again. The Office of the Public Defender supports the intent of this measure. We are always going to be supportive of look-back opportunities as people change and rehabilitate and evolve, especially in the custodial setting. One of the things that we do just want to highlight for this committee's consideration is our current sentencing scheme. There really is no way to modify a sentence under our current sentencing scheme without going back and resentencing them to a new sentence. And I don't know if that makes sense, but for example, if you get a prison sentence for a Class B felony under our certain sentencing scheme, under our current sentencing scheme, you must get the open 10-year term of incarceration. The paroling authority will decide how much of that you must serve before you can be released on parole, but there's no mechanism in the law to modify that sentence. It just is these indeterminate open terms for classifications of offenses. So while we appreciate and want to support look-back provisions under what is currently allowed in terms of sentencing, there's really no way to modify or adjust a sentence. There is a minor exception if someone was given an extended sentence, or their sentence was extended from 5 to 10 years or 10 to 20 years for certain things. You could maybe modify that to undo the extended portion of their sentence, but short of that, there's no meaningful way under our current sentencing structure to modify a sentence. So in practicality, we're not sure how this, if the bill were passed, how it would work, if that makes sense. And I can answer more questions if the committee has any. Thank you.
It's a hard one.
Yeah.
Okay, next, the judiciary. Jen Wong, welcome. Thank you for being here.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Jennifer Wong. I'm the staff attorney for the criminal divisions and judiciary administration. Similar to the Office of the Public Defender, the judiciary supports the intent of this legislation, and we have provided rather detailed comments in our written testimony regarding the issues that we feel that if this bill were to pass as is, it would not effectuate the intent of the measure. Essentially, to truly implement the intent of this measure, it would require a statutory framework necessary to replace indeterminate term sentencing for juveniles or some alternative in actually Section 2 of this proposed bill. And then on top of that, it would also require some revisions to the parole provisions of 706, 669, and 670. Again, similar to what Ms. Chang said, the state of Hawaii currently has a true indeterminate sentencing scheme. We are the only state in the nation that has it. The judges really do not have much discretion in terms of sentencing, especially when it comes to A felonies, murder, and attempted murder. It is the open term, and that is all it is. So therefore, having this look back provision would basically, there'd be nothing for the judge to alternate the sentence to or reduce the sentence to. There is a provision, I was asked about this earlier, there is a provision that was passed last year. However, that provision only permits the judge to reduce what is either a mandatory minimum based on the offense that was charged. So meth trafficking, for instance, has a mandatory minimum sentence of anywhere from 2 to 8 years. So we could reduce that for a juvenile, or based on what happens with the offense. So if the victim of the offense was over 60, for example, there is a mandatory minimum that goes along with that. And under the provision that was passed last year for juveniles, the court is permitted to reduce that mandatory minimum. But the sentence remains the same. It would still be the open 20 if it's an A felony. It would just, they wouldn't get the full mandatory minimum. So again, under this Hawaii statutory scheme, the actual time a person spends in custody will be determined by the Hawaii Paroling Authority. And therefore, they may be the better entity for this to be directed to, especially when you consider the really importance of finality of judgments, where a judgment has already been, and a sentence has already been issued by a court that has considered certain factors that the court has considered whether or not to even waive. The family court has decided to waive this juvenile in the first place. That has already been decided. There's been an appeal, and there's other processes, and the victims have relied on these sentences. So leaving the sentence to a particular thing and having the HPA kind of make these types of determinations at 12 years or in the future may be a better fit in order to establish those finality judgments. I am available for any questions.
Thank you, and I appreciate your detailed testimony. Next, Teresa Kamenos, Human Rights for Kids on Zoom.
Good afternoon again. Teresa Kamenos on behalf of Human Rights for Kids in support of SB 2325. Starting in 2005, the Supreme Court, in a series of decisions, established that children are constitutionally different from adults for the purposes of sentencing under the Eighth Amendment and must be treated as such. One way this has been effectuated by individual states is to afford people a meaningful opportunity for release based on demonstrated maturity and rehabilitation. Is the basis for this bill, the intent behind it. But we understand that there has been some conversation about kind of the technical language. So we would ask that the committee consider an amendment to Section 1 of the proposed measure to clarify the authority of judges to reduce the sentence of incarceration despite any mandatory sentencing framework that currently exists in the statute. Our proposed changes were included in our written testimony. I'd be happy to answer any further questions about that specific language. But the intent really is to ensure that judicial discretion to impose or reduce sentence is clear despite Hawaii's indeterminate sentencing structure by highlighting the specific provisions of the statute and giving courts clear authority to deviate from that framework. Because what we know about adolescent brain development is that the area of the brain responsible for reasoned decision making is not fully developed in children, and this is especially true for children with severe trauma histories whose development has been further impaired. But because the area of the brain responsible for reasoning and judgment is still developing in young people, any criminal behavior is likely a reflection of transient immaturity, making children more amenable to rehabilitation than adults. And that's why laws like this are so important. This measure doesn't guarantee release, but allows judges to take a second look at a person's sentence and reevaluate if it's still the most appropriate, given all the specific factors, including looking closely at a person's background and all of the factors pertaining to the development of youth. I'll just say one last thing. I understand that there's concerns about the integrity of sentencing and the finality of sentencing, but many other states have used similar judicial review mechanisms, despite that, as a way to address the constitutionality of extreme sentencing for children. And these include North Dakota, Maryland, and the District of Columbia. Thank you.
Thank you very much. Next, Nicola Novel Juris, Campaign for the Fair Sentencing of Youth. Not present. Jose Burgos, Campaign for the Fair Sentencing of Youth. Please
Yes, thank
proceed.
you. Thank you, Chair, Vice Chair, and members of the committee. My name is Jose Burgos, Policy Advocate at the Campaign for the Fair Sentencing of Youth. I'm here in support of SB 2325. CFSY is an organization that works around the country to help it end extreme sentencing for children. And I submitted a written testimony, just paraphrasing real quick. This work for me, this bill is actually personal. I am not only a policy advocate with CFSY, but I was also a formerly incarcerated child who served 27 years from the age of 16 to 43 on a life without parole sentence. So I understand what it is to be a child and be sent to prison and be told that you'll never amount to nothing. This bill is not a get out of jail free card. Just like myself, there were checks and balances. I had to go in front of a judge and prove that I was worthy of release. I had to go in front of the parole board and prove that I was worthy of release. And I think this bill will do the same. So we support SB 2325. Thank you very much.
Thank you very much. Anyone else wishing to testify on this measure? If not, questions, members?
Question, Chair.
Yep, Shimizu.
For Mr. Burgos who just testified,
Yes.
your situation, was it in the state of Hawaii?
No, sir. I am in the state of Michigan.
Okay, I just wanted to set that straight. Thank you.
Okay.
Other questions, members?
Chair,
Yep, Rep. Cochran?
for Ms. Awang, thank you, staff attorney for circuit court. And thank you for being here and your detailed testimony also. I'm trying to understand the portion in the bill, and I believe you speak to it, or was it public defender? The minimum serving of 12 years, but I mean, I'm figuring, so if the child is 16, then they committed it at 4. I mean, that's like a 12-year span as a juvenile.
Yeah.
You know what I'm saying? Like, I don't quite get
No.
what age, what is that? Maybe
So-
I'm missing the point on that.
So basically what this provision would do is, so what happens is when a juvenile commits a crime, and the prosecutor wants to ask the family court to waive them. Generally, they go to family court and we don't ever see them at the circuit court level. The prosecutor will ask to petition the family court to waive jurisdiction. If they waive jurisdiction, then they come up to circuit court in the criminal context where I am, and they are tried as just like any other adult for any of the crimes they might have committed. So any C felony, B felony, A felony, or murder, if the family court waives it. So whatever age they were at the time that they were waived, as long as they were under 18, then they come and they're tried, and if they are convicted, they are sentenced as an adult. So they could have been 16 years old, waived, and then they were sentenced to an open 20-year term. What this bill does, it says 12 years into that term, so when they're 28, they could petition the court to reduce that 20-year term and seek either their immediate release or some other reduction in their term. The problem that we have is that there's nothing to reduce it to.
Right.
So they wouldn't have been 4 years old, is what I'm
Okay,
saying. It would have been, it's whatever age they are when they commit the crime,
Got it.
and it's 12 years after they've been sentenced, when they're already in the custody of the Department of Corrections and Rehabilitation.
Okay, and then Chair, follow-up. Sorry, I know you have a question, Mr. Shimizu. So then also in the bill, it says something about defendants may not file a fourth motion and have to wait 3 years in between.
Yes.
So, I mean, what if so that's like 4 times you're going to the parole board or back to the judge?
To the court, yes.
To the courts, and then, I mean, what if you don't even have 3 years left in your sentence? So I'm just like, these numbers seem so, specific, and I would think that it wouldn't address all situations.
So mostly for those individuals, and to be honest, most of the individuals that we would be talking about, and it's still small numbers, because of the 12-year term, and B felonies are 10 years, C felonies are 5 years, so they would already be gone by the time this 12 years hit. We're looking at people who are serving a term for an A felony, robbery, or for a murder case or an attempted murder case, in which case they're serving life with the possibility of parole. So in that instance, at 12 years, you're generally talking about people who are serving life with the possibility of parole if you're going to give them the or the 3 chances that they have to wait 3 years for.
I see. Okay, all right. That was just, I was trying to, you know, figure out the numbers and years. Okay, thank you, Chair.
Thank you. Rep. Shimizu.
Thank you, Chair. Thank you for your testimony, awesome testimony. You know, from what I'm gathering in your testimony, there's 2 ways we can do it. And it seemed like the preferred way was going with the parole authority, making the adjustment to the parole authority. So if we wanted to pass this bill, is it salvageable with your suggestions? Because the first option is kind of overhauling a lot of things, yeah? So the parole authority route seems to be more doable and maybe accomplishing what this intent of the bill is. Would you comment on that?
Yes, thank you for the question. So I believe that there's probably 3 different possible ways in order to effectuate the intent of the bill. And there could be a combination as well of, say, a indeterminate sentencing scheme strictly for juveniles, and then a paroling authority scheme to have the paroling authority consider these things too. With respect to how you do it in this particular bill at this particular stage in the legislation, it would be a significant task, I believe. But we would be willing to work on whatever anybody would want us to look at.
Thank you for that offer.
Okay.
Thank you, Chair.
Thanks, Rep. Shimizu. Thanks very much. Any other questions?
Yeah, Chair, if you don't mind. So thank you. Was a reference to prosecuting attorneys, and they're saying how this is actually unnecessary and inconsistent, and potentially unsafe outcomes, and that there's already currently safeguards in place in our current legal framework for fairness. So, and they cite 3 different HRSs to state such. Are you in agreement? Have you had a chance to see what this is about? I know they're not here, so I'm sorry if I'm, putting you in a spot that you can't answer, but I was just.
So I did look at Ms. Kaeo's testimony briefly this morning. I do understand what they're saying, and it's kind of what I was talking about with respect to finality of judgments when certain things have already been considered in previous times, like when they were initially waived and that kind of stuff. I will say that with respect to a judge's discretion to sentence a defendant in an A felony and a murder or an attempted murder case, there really is no discretion for a juvenile. So even though the judge is looking at those 706, 606 factors and does consider those things, if it is an A felony, except for very few exclusions, they are going to get an open 20-year term. If it is a murder or attempted murder, they're going to get life with parole. So in that sense, even though they may have considered certain things in the sentencing scheme, there really is no discretion with the judge.
Okay.
That's the only
Thank
comment I would make.
Okay, well, thank you for that, and thank you, Chair.
Sure. Thank you very much. Any other questions? If not, thanks to all the testifiers trying to help us understand a complicated bill. Let's move on to the next measure. Senate Bill 2408, Senate Draft 1, House Draft 1, relating to compassionate access to medical cannabis. This measure allows terminally ill patients and qualifying patients over 65 years of age with chronic diseases to use medical cannabis within specified healthcare facilities under certain conditions, and it requires enforcement by the Department of Health. First up, we have the Attorney General.
Aloha Chair, Vice Chair, and members of the committee. My name is Alana Bryant, Deputy Attorney General. We would like to note that this bill allows covered healthcare facilities to elect to permit the use of medical cannabis, notwithstanding that cannabis is still a Schedule I controlled substance under federal law. We're recommending the deletion of section 7B at page 11, lines 3 through 8 of the bill, because that section contradicts the permissive nature of the bill. We also note that the president did sign an executive order in December 2025 directing the U.S. Attorney General to reschedule cannabis to Schedule 3, which may eventually reduce legal risk to healthcare facilities. However, we don't have a time frame for when the rescheduling will actually occur or what the rescheduling would actually look like in practice. Thank you, and I'm available for any questions.
Thank you very much. Next, Department of Health. I saw the director coming in. I know we're gonna listen to Andrew, but good audience over there. Go ahead, Andrew Goff.
Chair, Vice Chair, and members, Andrew Goff of the Office of Medical Cannabis Control and Regulation. This bill would authorize certain medical facilities to allow terminally ill patients to use medical cannabis while in the facility. That would be an important step into enable medical cannabis to be used by patients, and that is important to ease their condition. We would note that it is permissive, it is not mandatory, and we do agree with that. We think that strikes the right balance to authorize facilities that want to use this authority and not require everyone to take on the risk of breaking federal law. However, that being said, I would agree with other testimony that the restrictions to actually use the authority are fairly restrictive, and we don't know what's going to happen at the federal level. So it could be rescheduled soon. There are also initiatives for Medicare to cover certain hemp products, and so not knowing what's going to happen in the near term, it would be probably better to have a broader authority to allow facilities to make their own policies or at least put them into rules so that we can maintain flexibility to move with the federal law. Thank you for the opportunity to testify.
Thank you very much, Mr. Goff. Next, Paige Heckathorn Choi, Healthcare Association of Hawaii.
Hi, good afternoon, Chair, Vice Chair, members of the committee. Thank you for the opportunity to provide our testimony on this matter. We are currently in opposition to this measure. We are specifically opposed to the provision that the Attorney General has highlighted in their testimony. As testifiers have noted, federal law still classifies cannabis as a Schedule I substance. Hospitals, skilled nursing facilities, other inpatient providers are required to comply with Medicare laws, with federal laws, and with DEA laws regarding the use of cannabis in our facilities. The provision highlighted by the AG and in our testimony is problematic because it does limit a facility's ability to rely on federal requirements, and it effectively puts our providers in a position where they would have to choose between state and federal requirements. We do think it's entirely reasonable and appropriate for facilities to base their own policies on their obligations under federal law, and that is why we would ask for that particular provision to be removed. Thank you, and I will be available for any questions.
Thank you very much. Next, Karen O'Keefe. Looks like we've got testimony for two organizations coming from Ms. O'Keefe. Please proceed.
Aloha, I'm Karen O'Keefe, and I'm testifying on behalf of the Marijuana Policy Project. We strongly support allowing terminally ill patients in Kapuna to use medical cannabis preparations in healthcare facilities, but we request an amendment to the language. We strongly prefer the bill be mandatory, as was originally the case, and as is in the case in California, Minnesota, Mississippi, and other states. But absent that, it should at least allow all medical cannabis patients to be allowed to use medical cannabis, not just those who are terminally ill or 65 or older. Right now, the bill explicitly prohibits acute care hospitals from allowing non-terminal patients to use medical cannabis. As we understand it, there are currently some hospitals that are letting patients use medical cannabis, meaning this would actually make matters worse in some cases. We also urge that there be more flexibility to the facilities so they can adopt their own policies regarding medical cannabis, as the DOH discussed. Since federal law currently prohibits medical cannabis, some facilities might want to just look the other way and not document it at this time. That said, as was noted, federal law might be rapidly evolving. It might even have medical cannabis preparations covered by Medicaid soon. So we think that some facilities might want to have different facilities, such as potentially eventually allowing their staff to administer cannabis. So we urge amendments that we submitted. Mahalo for the opportunity, and sorry, my screen seems to be very fuzzy.
It's okay, I still hear you clearly. Next we have Shelby Billionaire on Zoom, not present. Next we have Robert Bentz on Zoom. Please proceed, Mr. Bentz.
Hello, Chair. Mahalo for hearing me. This is a deeply personal matter for me. I am unfortunately in opposition to this bill, even though I would be the strongest proponent. This bill is no longer Ryan's law. It needs to be shall. May is not how legislation is made. These healthcare facilities already may authorize it. It needs to be shall. In Hawaii, we had the May issue for the guns, and no one ever issued guns because then the chief would be responsible. So this is the same thing. This would make the healthcare facility responsible. If it's shall, the healthcare facility is complying with state law, making Hawaii back like Mississippi, which is ahead of us in this matter. We already have federal approval under the MMCREA, which was passed by help of Senator Schatz in December of 2022. So the healthcare facilities, as mentioned by Andrew earlier, could also already use the hemp preparations. So there is already before Schedule 3 the ability to have the patients work with the state, because I had a arteriovenous malformation the size of a golf ball. It's a random birth defect, and we have random birth defects in Hawaii like 20 times the average of national, and it moved my left hemisphere. I had to relearn how to walk and talk and everything from scratch, and I was the youngest person at a rehabilitation hospital, but for 3 different times I did not use my 329 medicine, and I had a stroke one time. I had a temporary stroke the other time, and I have used it both in hospitals and rehabilitation clinics in Stanford because it was so big. In Maui, they said, "Oh, we cannot handle this big of a AVM," so they sent me over there. But the doctors were amazed that it had been that big and it not ruptured to a stroke. They came up to my farm. They are very supportive, but the industry association act like there's G-men hiding around every door. There is many state rules and federal rules that we could do this right now. And with all the national changes, this is the only really time we can do this. And if it's May, might as well go and get rid of it. It would be the saddest April Fools ever. But I know hopefully you can change it and stand up to the executive branch, who is obviously only pro-dispensary. Mahalo.
Thank you very much, Mr. Benz. Is there anyone else wishing to testify on this measure? Senate Bill 2408.
Yes, yes, this is Alan Johnson with the White Substance Abuse Coalition.
Alan Johnson, yes, please go ahead.
Yes, Chair and all the representatives, Alan Johnson with the White Substance Abuse Coalition. We supported this bill. I want to explain what we're supporting and you understand how we work with as we're addiction centers. So somebody comes to us, residential, of course, that would never work. But in outpatient, where you might use it not in counseling, but outside of counseling, here's how we use that would be working. So you understand. You come to us and you say, my life is unmanageable. I have an alcohol problem and I'm using medical marijuana. So our medical team meets with you and says, well, we'll help you with alcohol. Is there an alternative to the medical marijuana that's not addictive? And they go, nope, that's it. Okay, so we help you with alcohol, and we say, is your medical marijuana use a cannabis addiction, which 5% of the people do have? And we say, oh, it is a cannabis addiction. So now we want to help you to get off that, to experiment more, or at least temper that. And if we find that the end of life issues that will help you with your alcohol, but it just have to live with your cannabis use disorder, your addiction, then we allow that. And so we want to be able to say this medical team working with the patient, we don't want to have an ability that impedes that process that says, oh, the patient gets to do, or somebody says you can't do. We want to be able to have a medical decision that allows medical marijuana, that we decide what's best for that patient to help their unmanageable life become more manageable. And that's why we're supporting this bill. And we hope this bill does that in some way that allows us to be okay with that. So I appreciate the opportunity to testify, and thank you.
Thank you very much. Anyone else wishing to testify on this measure? If not, questions, members?
Question, Chair.
Yep, Representative Mizu.
Question for Healthcare Association, Hawaii. Thank you for your testimony. My question is, if we were to adopt the Attorney General's amendments to address the federal issue, would you be okay with the bill?
We would certainly feel much more comfortable with the bill if we adopted what the Attorney General is recommending.
Okay, thank you. Can I ask a follow-up question?
Of course.
Attorney General, please. You know, Department of Health also offered additional amendments, and I'm not sure if you are familiar with them. Would their amendments be necessary also, you think?
Thank you, Representative. I did review their testimony, but I would have to discuss it internally with our office before I can give an official answer of whether or not we are okay with those proposed amendments.
Got it, okay.
That's how it works.
Got it. Okay, thank you, Chair.
Thank you. Any other questions, members?
Chair,
Yes, Rep. Cochran?
Department of Health is here though, yeah?
Of course.
Oh, yeah, hi,
This is
sorry.
Andrew Goff.
Yes, Mr. Goff, thank you. And I'm trying to, so your testimony was saying to keep it like authorization like more voluntary versus mandating.
That's right.
Is that correct? And in that sense, it would address the potential conflicts with the federal level laws? Is that?
It would allow a facility to make their own decision whether they want to take the risk on or not.
Okay. Okay, yeah, I just wanted some clarity on that point. Thank you so much for your testimony. And Chair, who was that? Was it the O'Keefe's? Marijuana
Karen O'Keefe with Marijuana Policy Project.
Yes.
Ms. O'Keefe, are you available?
Is she here still?
Please, go ahead.
Oh, hi, aloha. Oh, you're much clearer now.
Oh, good.
And so, yeah, I had wondering if you can elaborate a little bit more on the, open to all patients, not just terminally ill, and to ages not just 65 and above. Because I sort of had a question about that. So can you elaborate on your reasoning on those points?
Certainly. So as Robert Benz testified, he personally has already used cannabis in Hawaii hospitals. As we read it, current law already lets all of these healthcare facilities choose to allow medical cannabis. However, the bill was initially drafted to require the accommodation of people who are terminally ill or 65 and up. And that language remains in the current bill. So if you look at section 2 of the current bill and the definition of patient, the definition of patient is terminally ill or is 65 years of age or older. So under the amendments we submitted as the Hawaii Alliance for Cannabis Reform, we had just surgical changes where we suggest redefining patient as being any medical cannabis patient, and then also striking that language that says under 3B, that a general acute care hospital shall not permit a patient with a chronic disease to use medical cannabis unless they're terminally ill. And again, we understand because of feedback that this will be permissive, not mandatory. So it would just let hospitals and nursing homes and adult day facilities perhaps choose to allow medical cannabis regardless of age and condition. So people like Robert Benz could be allowed to use it.
Right, okay, and thank you for that. So, and that hence your point saying this would decrease compassionate access versus expands it, right?
Yeah, I'm concerned that if it was passed as is, it would be worse than the status quo because it explicitly would prohibit people like Robert Benz from being able to use medical cannabis, even if the hospital wanted to allow it.
Right. Okay, again, thank you for your time and expertise in the field. Thank you, Chair.
Thank you. Any other questions? If not, we're gonna move on. Thank you to all the testifiers. Next measure, Senate Bill 2418, Senate Draft 1, House Draft 1, relating to controlled substances. This measure repeals the law prohibiting drug paraphernalia under the Uniform Controlled Substances Act. This measure, first up, we have the Department of Health.
Good afternoon, Chair, Vice Chair, members of the committee. Tim McCormick with the Communicable Disease and Public Health Nursing Division of the Department of Health. The Department of Health submitted comments focused on the public health aspects of this measure. The items that people use in conjunction with their drug use do carry risk of infection and injury, and removing legal barriers to those objects may assist people in reducing harm associated with their drug use. We're not aware of any evidence that access to drug paraphernalia leads people to initiate or increase their drug use, and lack of access doesn't cause people to use drugs less. What happens with drug users who don't have access to drug paraphernalia is they share or they improvise, and both of those things carry risk for infection and injury. So we appreciate you considering this, and we appreciate the legislature continuing to look for opportunities to support people who use drugs, reducing the harm associated with their drug use. I'm available for any questions.
Thank you very much, Mr. McCormick. Next, State Health Planning and Development Agency.
Hello, good afternoon, Chair, Vice Chair, members of the committee. I'm Terry Vesperis on behalf of Dr. Jack Lewin, Administrator for SHPTA. We'd like to stand on our written testimony, but really the bill would help people seek sooner by reducing penalties tied to used drug items. And the bill keeps restrictions as it items, illegal drugs, and supporting more health-focused response where that people use drugs. And it also can help prevent overdoses and spreads of infectious diseases while encouraging treatment and connection to services. So we like to support this bill.
Okay, thank you very much. Next, Deputy Attorney General Mark Tom.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Attorney General Mark Tom for the department. Department submits testimony respectfully opposing 2418 SD1 HD1. First, would point out to the committee, currently possession of drug paraphernalia is a violation. It's been decriminalized since 2017 and is punishable by a fine. So this bill, which essentially legalizes drug paraphernalia, the department does not support it this time. As it relates to how this bill will support maybe programs such as the state syringe exchange program, it appears that this bill is unnecessary. Currently, through that program and through Act 106 2025, there is they built in criminal immunity for participants as well as staff that are participating in the state syringe exchange program. Last, the department would just point out just the way that this bill is written, the broad stroking amendments. It has unintended consequences. Some are pointed out in our testimony. Situations which were criminalized but now would be legalized would be allowing adults to provide drug paraphernalia to minors. It would also allow for advertisement of drug paraphernalia and essentially promotion of drug paraphernalia to individuals, minors, adults, anybody. So there does have some unintended consequences as it's written. I will be here for any questions, but the department does believe that legalizing in this way just sends a wrong message to the public as well as to users of illicit substances. Thank you.
Thank you very much, Mr. Tom. Haley Cheng, Office of Public Defender.
And good afternoon again. The Office of the Public Defender stands in strong support of this measure. As the Attorney General pointed out, since 2017, paraphernalia has been a violation when it was previously a Class C felony. And that is a recognition of a lot of the things that this committee has heard regarding increasing access to safer use supplies, increasing and reducing overdose and infectious disease risk, as well as the disproportionate impact this has on marginalized communities, including our houseless population. We also, from the public defender's perspective, want to highlight that the current criminalization of paraphernalia only, which is a violation, acts as a gateway or access point for law enforcement for other charges, and we've seen that time and time again. The reality of how many people are actually charged with these violation offenses is very few and far between. What it does serve as, though, is a reasonable suspicion or probable cause type of access to then try to investigate and do other things. And again, all of the health risks that this committee has heard. We also want to highlight, as we've outlined in our testimony, that we believe this measure is reflective and works in harmony with another measure that is currently in the legislature, which is the Model Penal Code Review Bill, which is SB 2721, which is currently seeking to reduce residue possession of drugs to just a misdemeanor offense when it is currently a Class C felony. All of these things are recognitions that drug addiction is a health issue, a substance abuse or a substance addiction issue, and it's not necessarily a criminal issue. And I think we're shifting towards that, and I think this measure supports that. So I'll be available for any questions. Thank you.
Thank you very much. Next, Honolulu Police Department, Jerome Acaro on Zoom.
Yes, hello, dear Chair Tarnas and members. I am Lieutenant Alan Liu of the Honolulu Police Department, speaking on behalf of Jerome A. Pacaro. He is the Major of the Narcotics Vice Division of the HPD, City and County of Honolulu. The HPD respectfully opposes Senate Bill number 2418 SD1 HD1 relating to controlled substances. The HPD opposes the bill based on the concern that repealing drug paraphernalia laws could inadvertently encourage increased drug use and contribute to public health and safety issues. First, decriminalizing drug paraphernalia may lead to easier access to items that support substance abuse, potentially normalizing drug use, especially among youth and vulnerable populations. Public health research generally indicates that greater availability of drug paraphernalia can correlate with higher rates of substance abuse. Second, unregulated paraphernalia could lead to public safety concerns such as discarded items in public spaces and pose risks of injury or health hazards to the community. The HPD respectfully urges you to oppose Senate Bill number 2418 SD1 HD1 relating to controlled substances. Thank you for the opportunity to testify. Sincerely, Major Jerome A. Pacaro, Narcotics Vice Division. Thank you.
Thank you very much. Next, Nikos Leverins, Hawaii Health and Harm Reduction Center, or his representative.
Yes. Thank you, Chair Tardis, Vice Chair Poi Poi, and members of the committee. Heather Lusk, Executive Director of the Hawaii Health and Harm Reduction Center. Nikos sends his regrets. We stand in strong support of this measure. The Hawaii Health and Harm Reduction Center, and previously CHOW Project, its predecessor, has over 30 years of experience in providing syringe access and health issues to people who use drugs. And according to the Hawaii Department of Health, has kept HIV and other infectious diseases like hepatitis C low because of this. Currently, my staff are at legal risk if they hand out paraphernalia that could actually not only reduce disease, but builds a rapport to allow folks to access drug treatment. So for example, we have over 100 people who used to actively use substances through our program now accessing drug treatment through our program. Additionally, we have a very a very unintended consequence why there is a current exemption in the drug paraphernalia law that allows my staff and people accessing the syringe exchange program for syringes only. That does allow people to have access to that paraphernalia without criminalization. What we're actually seeing now is people who don't want to inject and maybe want to smoke, for example, actually injecting, which is a much bigger health concern, not just for infectious diseases, but overall with substance use disorder. We understand that this seems counterintuitive to public health to decriminalize to repeal the paraphernalia law. However, we feel strongly that law enforcement, which we work closely with in many areas, do already have the tools to hold people responsible that offend or that sell or that utilize substances in ways that they aren't intended, and that the drug paraphernalia repeal would allow us to do public health work, not only connecting people so that they can stay safe from HIV, hepatitis, and overdose, but then build a relationship, because many folks are afraid to come to us because of the paraphernalia and what the public defender said will be utilized for them to then get into the system. This allows us to then provide treatment, provide other resources so that hopefully people can be able to reach their goals and become contributing members of the community. So we stand in strong support of this measure. Thank you so much for the opportunity to testify. Oh, and briefly, as far as we know, respectfully, we've never seen any research, which I'd love to see it, if there is any correlation between increased access to paraphernalia and increased use. We have not seen that, and so we actually feel that by providing this, it actually increases the ability to get people into drug treatment. Thank you.
Thank you, Ms. Lusk. Next, Kat Brady, Community Alliance on Prisons and Support, not present. Is there anyone else wishing to testify on this measure? Yes, please, come on up. Please introduce yourself.
Aloha, Chair, Vice Chair, and members of the committee. My name is Margaret Mejia, and I'm submitting testimony on behalf of Hawaii Christian Coalition. We strongly oppose SB 2418 SD1 HD1 relating to controlled substances. Drug paraphernalia promotes drugs, and we want to protect children, teenagers, and our ohana from drugs and the effects of drugs. Mahalo.
Thank you very much. Would you be so kind as to give your name and organization name to our clerk over here so we can keep track? Thank you very much for providing testimony. Is there anyone else wishing to provide testimony on this measure? If not, questions, members? Rep. Shimizu.
Department of Health, please. You know, thank you for being here. Thank you, Chair. As was mentioned by Attorney General and Public Defender, the state already reduced in 2017 Class C felony to a violation. Do we have data that would support further reductions that show this is needed?
So we certainly have anecdotal information, particularly from the syringe exchange program, where even a fine of $500 can be a really significant barrier. The Attorney General did point out that last year there were some changes that were made to provide some additional allowance for access to certain paraphernalia for syringe exchange participants. That is limited to syringe exchange participants, so others who inject drugs and don't use syringes don't have access to that protection, and people who use drugs other than through injection don't have access to that as well. So that's really where we see this continuing to act as a barrier to individuals accessing paraphernalia in ways to reduce their risk of infection and injury.
You know, I can agree with that you know, we're trying to help people by investigating different pathways. I guess it would be easier for me to accept this bill if, as we try to decriminalize things, we also increase treatment facilities and help that way. So the problem is when I have a opposing testimony from people like Attorney General, Honolulu Police Department, Hawaii County Prosecuting Attorney, it's very difficult to disregard their important testimony. So how would you reconcile that?
So thank you for that. We really do understand that is really part of the reason the Department of Health's testimony is neither in opposition or support but providing comments. We understand that the public health considerations are not the only things that the legislature needs to consider. And so we understand that it's not simply a question of public health that you have to base this decision on.
Thank you, Chair.
Sure. Any other questions?
Chair, for Attorney General's office.
Right.
Aloha, Deputy Tom. So you, in your testimony, you're saying this is sort of a legalization of paraphernalia and that it would allow advertisement for such items, you know. So what do you, I'm trying to think of what advertisement these are. I mean, advertisements for, because there's the needle exchange, so you're talking about pipes and
Pipes or any objects that fall within the definition under 32943.5, which is right now it says drug paraphernalia with the intent to use drug paraphernalia to plant, propagate, produce, possess, prepare, test. Any items that could be used as drug paraphernalia could be fall under this situation where it could be advertised. Pipes could be advertised, anything that might be used as drug paraphernalia.
okay. I'm just trying to, I mean, I've never,
Okay.
I just never seen glass pipes or, I mean, you put cocaine with baking soda, but anyways, okay. No, I totally agree that this needs to be a law, but yes, thank you.
Any other questions? If not, thank you very much to all the testifiers. Let's move on to the next measure. Senate Bill 3133, Senate Draft 2, House Draft 2, relating to preventive medicine. This measure specifies that no person is subject to liability for providing clinical preventive services in accordance with the Department of Health recommendations. It requires health insurers, mutual benefit societies, health maintenance organizations, and plans issued by the Hawaii Employer Union Health Benefits Trust to provide coverage for clinical preventive services. It authorizes the Department of Health to make recommendations relating to clinical preventive services and issue standing orders for medications and immunizations. It clarifies that for child health supervision services coverage, the prevailing medical standards include recommendations by the Department of Health. Prohibits denial of coverage and prior authorization for clinical preventive services based on medical necessity. Specifies that a registered pharmacist may order a vaccine in accordance with the recommendations from the Department of Health, and exempts this measure from an auditor impact assessment report. First up, we have Department of Commerce and Consumer Affairs, Insurance Division. Could you come on up to the rostrum? I want everyone watching on TV can see you and hear you. If you could introduce yourself and briefly summarize your testimony.
Chair Tarnas and members of the committee, I'm Marlene Ige with the Department of Commerce and Consumer Affairs Insurance Division. The department stands on its written testimony offering comments. Thank you.
If you could please summarize the highlights of your testimony. Sure. I want the public to understand what we're doing here.
Okay. The department notes that it is unclear whether the amendments in sections 3, 4, and 10 of this bill would trigger the deferral requirements under the Affordable Care Act if state mandate benefits that are in addition to the essential health benefits as defined in the state's benchmark plans, if these mandates are considered in addition to those essential health benefits, the state is required to defray the cost of those additional benefits. However, the current draft of the bill does incorporate safeguards to mitigate the risk of state defrayal liability through repeal mechanisms.
Thank you. I appreciate you providing that summary. Next, the Department of Health.
Good afternoon, Chair and members of the committee. I'm Sarah Kemble, the State Epidemiologist and Chief of the Disease Outbreak Control Division, testifying on behalf of the Department of Health. Thank you for the opportunity to testify in strong support of this measure. We see this measure as ensuring protection for patients and families who are seeking immunization services or other preventive services that are evidence-based without cost sharing. And we stand on our written testimony, but are available for any questions or further explanations as needed.
Thank you very much. Let's see, next we have State Health Planning and Development Agency.
Hi there, good afternoon. Terry Vesperis for Dr. Jack Lewin for SHPTA. we'd like to stand on our written testimony, but like the doctor ahead of us said, that again, this would be help make sure that people can continue to get important preventative care, including vaccines and other preventative services, evidence-based clinical services without cost sharing if federal protections should change. Again, we'll refer to Department of Health and DCCA on any of the operational details, but we're in strong support.
Thank you very much. Next, Jamie Detweiler on Zoom.
Can you hear me?
Yes, we hear you loud and clear. Please proceed.
Thank you. Aloha, Chair Tarnas, Vice Chair Poipoi, and members of the committee. Jamie Detweiler, Hawaiian Islands Republican Women. I'd like to also add, sir, that I have over 33 years in healthcare administration and a direct practice licensed social worker. So we stand in opposition to SB 3133. I understand that the mandate in the bill is to have health insurance coverage for these preventative measures. What we're opposed to is this measure places excessive authority into the hands of unelected bureaucrats, such as the Advisory Committee on Immunization Practices. It could lead to centralized control over medical decisions and care guidelines. As a result, it may introduce biased advice, impose unwelcome mandates, and diminish informed consent. This measure also incidentally uses the word recommendation 41 times. A recommendation means a suggestion or a proposal for an action, usually from an authoritative source. May I respectfully remind this committee that a recommendation is not enforceable under the law. Many health insurance plans exclude preventive services that help Hawaii residents who choose natural, non-toxic options to boost their immunity, covering proven efficacy of vitamins and supplements instead of vaccines would offer a safer alternative, or I should say, in addition to vaccines for those who would like to choose that. In summary, I would like to respectfully remind the committee that recommendations and mandates are temporary measures and not legally enforceable, as they do not constitute law. Please vote no on SB 3133. Mahalo.
Thank you very much. Walden Au, HMSA. Welcome, sir.
Good afternoon, Chair Tarnas, Vice Chair Poipoi, members of the committee, Walden on behalf of HMSA. We stand on our written testimony offering comments, and we appreciate the dialogue that's going on with this measure as well as other measures that are looking to address changing policies at the federal level. We're available for any questions if you have.
Want to highlight your comments, please?
That we appreciate the conversations going on.
Okay, that's your comments.
We have brought in our own coverage for vaccinations over the last 2 years, and that should the Department of Health feel that there is a need to continue to at least have guidelines or recommendations, we're supportive of the intent of the measure.
Okay.
Thank you.
Thank you very much. Next, Hawaii Christian Coalition. Welcome back.
Aloha, Chair, Vice Chair, members of the committee. My name is Margaret Mejia, and I'm submitting testimony on behalf of Hawaii Christian Coalition. We oppose SB 3133 SD2 HD2 for many reasons. First, this bill goes against patient rights of bodily autonomy and informed consent. And we believe that the Department of Health should be liable for any vaccine injury or death. Second, this goes against the First Amendment, the 14th Amendment, and more. The Due Process Clause prohibits states from depriving people of life, liberty, etc. Many die or are permanently disabled from vaccines. That definitely goes against their life and liberty. There's no liberty if people are forced against their will, their conscience, and their convictions. Freedom of religion in the First Amendment. This violates the First Amendment. The aborted fetal parts are used in development of vaccines, and every COVID vaccine contains fetal tissue cells. Many Christians, Jews, and Muslims have an issue with putting fetal tissue cells into their bodies. Aborted fetal parts are used in development of vaccines, and every COVID vaccine, every one of them, contains fetal tissue cells. The Moderna COVID shot, as you can see in my testimony, at length I described what fetal tissue cells are involved in those, the HEK 293, and I have a lot of research on there. I won't go through all that because there's a lot of testifiers here. And then the Pfizer COVID shot also contains the same fetal cell, HEK 293. And the Johnson & Johnson COVID shot contains fetal cell line PER-C6. And some people aren't even aware, but the Johnson & Johnson COVID shot was revoked by the FDA in 2023. So there's many studies that show that COVID vaccines and other vaccines, most of them now contain mRNA, and they're associated with increased abortion, miscarriage, and birth defect rates. Therefore, the Department of Health should be liable for any negative effects or death from the vaccines they are administering. Without liability, there can be no accountability. Please vote no on SB 3133 SD2 HD2 and protect the constitutional rights and the well-being, pursuit of happiness of your constituents. Third, a pharmacist, pharmacy intern, or registered pharmacy technician is not qualified to administer vaccines or dispense any medication without knowing the child's medical history that is only available to his or her pediatrician, who's a qualified doctor and licensed under the state of Hawaii. There's a huge difference between a pharmacist and a doctor. And then I heard someone talk about mandates earlier, and just so people know, mandates are not a law. Prevailing medical standards, and I'm quoting that, that's in the bill, should not be determined by the advisory committee from the Department of Health and Human Services and the American Academy of Pediatrics, since all of these organizations promote vaccines. We believe people should have a choice. Hawaii Christian Coalition believes in patient rights, including bodily autonomy, informed consent for adults, and parental rights so that parents can decide if they want to vaccinate their keiki or not. Mahalo.
Thank you, Ms. Mejia. Next, Cheryl Toyofuku.
Aloha Chair Tarnas and members of the JHA committee. My name is Cheryl Toyofuku and I'm in strong opposition of SB 3133 SD2 HD2. Because it is on preventive medicine, and as a mother, as a grandmother, as a retired registered nurse and a health advocate, yes, we do want to prevent our children from becoming ill or going into the hospital, same as our kapunas. Yet this particular bill, SB 3133, is focusing on vaccination as a preventive medicine and recommendations by the DOH, ACIP, the USPSTF, the HMSA, HMA, all these organizations that are promoting vaccines. And we've seen the collateral damage that has been very severe for our family and friends who have had vaccine injuries or deaths, and giving more authority to the Department of Health to have standing orders for medications and vaccines, rather than parents who should have they should be the prevailing medical standards actually for their own family. And to have no liability, this is a very strong concern of mine, because who's going to be accountable and responsible for the vaccine injuries that do occur from the vaccinations? So requiring health insurance also when we're not even insuring other preventive measures, as the last testifier did mention, that we have so many other natural immunity versus the artificial immunity by these vaccine jabs. We do have natural immunity supplements, many health preventive measures that could help, really truly help our keiki and our kupuna. So please vote no on SB 3133. Thank you.
Thank you very much, Ms. Toyofuku. Next, Kim Cordery. Not present. Next, Teresa Armbruster.
Aloha Chair and committee members, I'm Teresa Armbruster, and I stand on my written testimony in strong opposition to this measure. I want to emphasize a few points. Well, first of all, mandating a health insurance coverage is going to increase our insurance premiums. So why should we pay for these vaccines whether we want them or not? I don't think that is right because there are, like other testifiers said, there are all the alternatives. That's not being covered. So that is not fair. And also, even though the Department of Health can issue standing orders, these orders must respect and uphold the person's constitutional right to choose and informed consent right to refuse medical treatment and vaccines. And the Director of Health and all who follow these vaccine recommendations must be held accountable for any harm or death caused by these shots. When there's no liability, there's no reliability on these recommendations. There must be accountability. And the American Academy of Pediatrics was listed as one of the sources for prevailing medical standards. But please note that they are facing a RICO lawsuit for fraudulent vaccine safety claims while being funded by vaccine manufacturers, Pfizer, Moderna, Merck, and Sanofi, and incentivizing pediatricians for high vaccination rates. This lawsuit details decades of malfeasance. It was harming numerous children, including 3 deaths for following these AAP recommendations. And also I want to ask, why is there not that impact assessment report that's required to be done before something like this is coming into a bill, especially for mandating insurance coverage? I respectfully ask you to require that assessment report because it seems like there might be a significant impact. So that needs to be addressed before you can just shove that to the side. And also, I just, let's see, what else there's one other thing I want to say is that, in case you haven't done any research on vaccines, here are some of the facts about the vax and their toxic ingredients. So I would ask you, if you don't know, you can go to learntherisk.org and please do your research because we really do want to keep everybody's health and not just big pharma wealth. And I ask you to vote no on this measure and do not allow the Director of Health to become the dictator of health. And just, there's so many other alternatives, so please look at all of those and not just dictate one source of preventive services. So, aloha keakua and the love of God be with you.
Thank you very much. Next, James Wallace. Not present. Next, Loretta Dubin.
Hi, respectfully, Chair Tarnas, rest of the committee, my name is Loretta Dubin. I am a retired RN, and I strongly oppose SB 3133. And we need to stop the DOH from becoming a dictator of health. Okay, I'm not saying any particular person, I'm saying the DOH in general. It's absolutely unconstitutional to have standing orders. I know what standing orders are working as an RN, and it's dangerous. For one thing, any substance that we put into our body, you know, it's not a one size fits all. So a standing order would be, that's for everybody. We have to consider the health of the individual. We're all different. We're all different from one another. Our genes, genetics, will be expressed when we are exposed to certain different substances and toxins. That can be environmental, can be vaccines, all different kinds. So that has to be taken into consideration. There cannot be, the other point I want to make is about a pharmacist being able to make that decision, and that kind of an order. No bueno. It's very important that, and they would be giving their farm techs the authority to give those shots. And those farm techs and the pharmacists are not trained in advanced cardiac life support in case somebody has an adverse effect from one of those shots that's given in, say, Long's or Walgreens. Dangerous again. Okay, also, there can be no insurance coverage for all these vaccines that's on this DOH list. Insurance rates will certainly go up for everyone. Especially, I mean, people who don't even want the shots, their insurance is gonna go up. And some seniors will potentially receive less Social Security benefits. Many will be refusing these vaccines. As been mentioned earlier, there's dangerous substances in the shots: aluminum, human aborted fetal tissue, MSG, polysorbate 80 and 20, and formaldehyde, embalming substances. Again, no bueno. Okay, if there is risk involved by injecting or ingesting anything into one's body, then there has to be liability on the part of whoever is recommending or mandating the same. Please vote no in opposition on SB 3133. Thank you.
Thank you very much, Ms. Dubin. Next, Michael Goloyu on Zoom.
Good afternoon, Michael Goloyu Jr., he, him pronouns, President of Pride at Work Hawaii. We stand in strong support of this measure. Vaccine saves lives, and stop. That's it. It's amazing that at this day and age that we have people saying that they've done their own research. And thanks to that, we now have seen measles making a back. We almost eradicated that, but measles is making a comeback as we've had these scares here in Hawaii. They're like, people can make their own choices, but when you end up making your own
Michael, just focus on the bill, not on other testifiers, please.
Well, the impact for this of the other testifiers is that when we don't have full vaccination for all those who can take it, we put everybody else at risk, those that are unable to because of their compromised immune systems, that these things do have a negative impact on all of us. This bill will help protect us, I don't want to see the measles come back any more than polio, which if we keep going down the route we are with some of these people, we are going to face that again. We encourage you to pass this bill. It's the right thing to do. Our federal government's not going to be here to support us. And anybody who thinks vaccines are okay, are not necessary, should go visit American Samoa and those that they lost there due to the measles outbreak. So we encourage you to pass this bill to protect us. Mahalo.
Thank you very much. Linda Lee on Zoom, not present. Anyone else wishing to testify on Senate Bill 3133? Yes.
Here.
One person here in the room before I come to person on Zoom. Please, come on up and introduce yourself.
Hi, my name is Brunel Oku and I oppose this bill. I feel like it was written to protect the profits of the insurance and the pharma industry, and I think that they don't need any more protection. I feel like we should be protecting the people that are maybe injured, or actually the personal people. Actually, I feel like we should protect the people that are being injured by vaccines or whatever, I think we should protect their rights versus big pharma. I feel like this is just written to protect the wrong people. Thank you.
Thank you. If you'd be so kind as to give your name and any organization, if you're representing an organization, to our staff there. Thank you. Next, anyone else wishing to testify? There is someone on Zoom. Please proceed.
Aloha, Chair, Vice Chair, and members of the committee. My name is Greg Masakian. I'm currently a Kupuna advocate. I serve as president of the Kukua Council and vice president of the Hawaii Alliance for Retired Americans. I'm only going to be speaking on behalf of myself as an individual, and I strongly oppose this bill as it's written. I understand that there's an intent to try to do good, but I'm also fully aware of the adverse reactions that many people have had from the COVID vaccinations. I know some people at CDC. I live with someone who used to work for Genentech, so doing global drug studies. And from what I collectively know and from the experiences that I'm aware of from personal, family, friends, and others, I know there's a high risk. And It's different than the measles vaccine. So that's something that's, been tried and tested for many, many years. So with that said, until there's proven vaccinations that are really vaccinations, these COVID shots that people were getting, it wasn't a vaccine to prevent you from getting COVID. In fact, some people got COVID from it. Until that's proven and tested drug technology, I strongly oppose any kind of bill like this, and I hope that the committee will not move this forward. Thank you so much.
Thank you, Mr. Masakian. Anyone else wishing to testify on this measure? Otherwise, no questions. Questions, members?
Question.
Yep, Rep. Shimizu.
Department of Health, please. Sir. All right, I get to ask the director. Thank you, director, for being here. As you can hear from the opposing testimony, there are concerns that this bill may give or will give Department of Health a lot of authority. So my question would be, what processes or rules or even reviews will there be to provide the public accountability and transparency on what the Department of Health does with this new authority, should this bill go through?
Well, for the question, I'm Kenny Fink with the Department of Health. Under the Patient Protection and Affordable Care Act, there are two provisions of note. One was that health plans cover vaccines recommended by the Advisory Committee on Immunization Practices without cost sharing. The other one was that they cover clinical preventive services recommended by the U.S. Preventive Services Task Force with an A or B grade. This measure would preserve the coverage under those that were still in effect as of January 1, 2025. So this does not expand what was already covered. The intent of this measure is to preserve access. So there are comments on cost. All those benefits that this would ensure preservation of access to are already covered. They're already incorporated into insurance rates, cost of insurance plans, okay? The concern from a cost perspective is if vaccination rates go down and there's more illness, you are more likely to see visits for illness, hospitalizations for illness, which are far more expensive. Those may drive up health insurance rates, not vaccinations. There's two terms I want to go over. One is cost effective and the other is cost beneficial, cost savings. Cost effective means what's the dollar amount to have a quality of life in an extra year. So we call it quality adjusted life years. And we may say that's of good value, okay? Cost benefit means you'll spend money on a service and it will save money.
Excuse me.
Immunizations are one of the few things that are cost effective. I'll get there,
Chair,
if I may.
Excuse me, Director.
You want to ask the question?
I did ask the question, and I don't think I got an answer.
Maybe you want to ask it again.
Okay, the question was,
Go directly to the
this bill is giving Department of Health authority over healthcare. And my question was, what is the formal process that you will be doing, rules that you be setting up, and that would provide transparency and accountability to the public? Because I think the public wants to be.
So as it began, so it's bounded. It's bounded by those services that were recommended by the U.S. Preventive Services Task Force with a grade or B recommendation as of July 1st, I think it was 2024. So it is bounded by that. It cannot exceed those services that were not recommended as of that date, okay? The immunizations that this would cover have to be approved by the FDA. So this is bounded by those requirements, okay? The FDA has to approve the immunization. It has to have already been covered by the U.S. Preventive Services Task Force. And these services at a maximum are already covered today. So that is the limit. This is not expansion. This is intended to preserve access.
Chair, can I get a follow-up?
Just to follow up, is there any process that you go through that would provide public awareness about your work in this area so that there's transparency. I think that was really what Rep. Shimizu was asking about.
Yes, we certainly do public notice, information on our website. Again, this is just to allow individuals to choose. So we are happy to provide information for individuals to know what they have access to should they choose to receive those services.
Follow-up question, Chair.
Okay.
In your first response back to my initial question, you have mentioned that I think ongoing is preserving certain things that are already in place. So if that's the case, then why do we need this bill if it's already in place?
We need this bill, this is a important question, why do we need this bill? There have been changes at the federal level, particularly with regard to the Advisory Committee on Immunization Practices, that recommendations have changed. Now, a recent court decision has stayed those recommendations, but the risk is that those recommendations may end up being in effect. As those recommendations have removed because those recommendations do not routinely recommend certain vaccines, those are changes. And because the Affordable Care Act talks about coverage without cost sharing, if the ACIP no longer recommends it, it no longer is available without cost sharing. So these decisions now at the ACIP, the recent ones, are actually removing choice for individuals. Those who would choose to get vaccinated would not have access to it without cost sharing. They've removed that choice. This is intended to preserve choice to access of those preventive services without cost sharing for those who choose to receive them.
Okay. Rep. Garcia?
Thank you, Chair. For Dr. Fink, is it your understanding that the reason why the federal government and this new administration on that certain panel remove certain vaccinations from the recommended list is because of their lack of science? Or, I mean, because in my understanding, their reasoning for removing these vaccinations was based off of evidential claims. Is that your understanding as well?
So the Advisory Committee on Immunization Practices in the past would systematically review a body of evidence, go through a rigorous process evaluating the quality of that evidence, and follow a evidence to recommendation framework that would result in the recommendation. This current composition of the HIP has not followed that process.
And what is that process?
They did not systematically review the current available body of evidence. They have no established evidence to recommendation framework. So it is unclear the basis of the recommendations. It has not been transparent, it has not been systematic, there's been an unclear process.
Okay, and then follow up, Chair.
Yes.
A testifier mentioned earlier about measles. To my understanding, it's still the position of the federal administration to recommend the measles vaccines and even the MMR vaccines, even though that has had some complications. Would you agree that if this bill does not pass, that measles could perhaps uptick here in Hawaii?
This bill preserves essentially access to the vaccine. Whether or not people choose to get vaccinated is a different matter.
Measles is not part of the conversation here.
I'm not sure I understand the question.
So the previous testifier mentioned that if the bill doesn't pass, we'll see an increase in breakouts here in Hawaii, such as measles. But it's my understanding that the current administration and those boards at the CDC and stuff who makes these recommendations are still recommending measles for vaccination.
As of today, you are correct. The current ACIP recommends the MMR vaccine. They did change the recommendation from the MMR-V combination vaccine at 4 years old. So that's a minor point, but it's a point, and it does not preclude them changing their recommendation in the future. But at this point in time, you are correct.
Okay, and then lastly, Chair.
Yes.
Would you be opposed to any changes made from the list of vaccinations recommended? Are you opposed to any changes made to it? Because you want to preserve what was there from January 1, 2025, correct? Okay, if there's any changes made in the future, would you oppose any of them?
We need to review the evidence to determine if there is a need to recommend another vaccine. Currently, with the changes of the FDA, that will be required to cover a new vaccine. It's become very burdensome. I don't anticipate a new vaccine to be FDA approved in the foreseeable future. There may be new vaccines developed for new conditions, and at that time, it would be important to systematically review the evidence and make a determination at that time.
Thank you.
Okay, thank you. Any other questions? Representative Takayama.
Director Fink, I have a question. The bill is originally introduced by the administration, proposed an advisory committee at the local level. A previous House committee removed that committee, advisory committee. Is it your preference to have an advisory committee or do we not need one?
Thank you for the question. One of the words we're talking about now a lot is trust, right? And there's been a decrease in trust in public health institutions. I think it's important for me. Trust is not agreement. Trust is transparency. People say what they mean. They can predict someone's position because it's consistent. Folks may disagree with my position, but hopefully I've been consistent and they may understand my intent. Healthcare providers are the most trusted entity through surveys. People trust their doctors the most for information. So one of the ideas for the advisory committee was that if practicing physicians from our community were making recommendations, would that help lend trust to the process? So that was an interest in doing that, okay? In previous hearings for this measure, testifiers have raised concern of should there be a panel of unqualified people making recommendations and arbitrarily and capriciously selected with this one ideology that could be problematic, and that could be problematic. The other question was there's no elected official, there's no way accountability. I'd just like to say that the Director of Health is Senate confirmed. So there is an approval process and checks and balances for particularly having the Director of Health. With regard to the advisory panel, for people who might participate on that, it was important that they have immunity for the sake of their participation. And there was some concern about giving that immunity. And without that immunity, I would be concerned that we may not be able to get people to agree to participate on that committee. So as these measures have advanced, the committee was removed, the immunity for the community members, the committee members was removed, and that's where we are today. Which version do I prefer? I prefer the version that's more likely to pass.
I just might note that the original bill was fairly specific in terms of the membership of the advisory committee, in terms of the appointees being from Hawaii Medical Association and different professional medical associations. Isn't that right?
So because vaccines are for individuals to make the choice and they would have to agree to receive the vaccine, that having the providers who be the ones interacting with those patients and providing the information for the patient to make that decision, that they would be useful. So yes, it included representatives of those bodies that represent those providers who were caring for our patients and talking with those patients. So whether it was the American Academy, local chapters of the American Academy of Pediatrics, American College of Obstetrics and Gynecology, family physicians. So the committee was comprised of representatives of those provider organizations. Without going into the federally qualified health centers, we tried to have a broad spectrum of those involved in the care delivery to offer this service.
Thank you. Thank you, Director. Thank you, Chair.
Sure. Any other questions? Okay, could
Last question.
okay, we'll go to Rep. Cochran first and then to Rep. Shimizu.
Thank you, Director Dr. Fink, for being here. So, this is saying that no person is subject to liability for providing clinical preventative services in accordance with Department of Health's recommendation. And they're pointing to you, you're the Department of Health recommendation? you mentioned, you know, it's a choice to get a vaccination, but if something negative occurs, that person who administered that vaccination is not liable? Or who is liable, I guess, at this point?
Yep. When people receive services or undergo procedures, they should provide information about potential benefits and harms, right, for the individual to make that choice. For the individual to choose to receive that service, just because there was an adverse event doesn't mean there was wrongdoing in the provider providing information or offering the vaccine. Now, that immunity was simply to recommend a vaccine. It does not apply to any negligence into the administration of the vaccine. So there was a comment raised about pharmacists, and you know, pharmacists are not qualified to offer it, and they may do it incorrectly and make mistakes. All these vaccines, pharmacists under Hawaii state law and under a current emergency proclamation, pharmacists can administer all these vaccines today. So this does not expand the scope of pharmacist vaccination. So the immunity is not applied to any negligence. It would simply be if they were following a recommendation of the Department of Health that may differ from a recommendation of the Advisory Committee on Immunization Practices for the sake of offering the vaccine.
Okay, sorry, and a follow-up, and it also is stating that, it didn't really tell me who's liable, but it also states that the Department of Health, it can issue standing orders for medications and immunizations. So orders, like what is that? What is this telling me?
No, thanks for the opportunity to clarify that. There may be some misunderstanding with the term order.
Yeah.
So physicians, when we say we prescribe, right, or we can order a prescription, order a service, and someone else may provide it. So if I were in practice and I talked to the patient and the patient agreed to get a flu shot, right, I might write the order for a flu shot and my nurse could come in and give the flu shot. Okay, so it's under my guidance. The standing order comes out of a couple of things. So let's say we try to narrow it. So for medications, if, for example, there are a whole bunch of people who are exposed to an individual with tuberculosis, okay, and they should get post-exposure prophylaxis. We might be able to deploy public health nurses to assess them, evaluate them, and give them medication to help prevent them from getting tuberculosis, okay? That would be a public health standing order for those public health nurses to be able to dispense or administer that medication. For vaccines, that came up because current Hawaii law says pharmacists can administer vaccines if it's both FDA approved and ACIP recommended. Now, we had a very unique circumstance. So for the COVID vaccine, the FDA changed its recommendation. So it lost its FDA approval, but the ACIP still recommended it. So even though the ACIP recommended it, because the FDA no longer approved it, pharmacists couldn't administer it. So this is to cover those scenarios where pharmacists could still administer it if it is approved by the FDA for some indication.
Okay, and one last, real quickly, and so this measure is also exempting an auditor impact assessment report. Are you aware and do you agree?
So the reason for that is because these services today are all currently covered. So the impact of covering of something new that's already covered, that is the reason why. It's not an additional coverage. It was required to be covered on the Patient Protection and Affordable Care Act, and these are all currently covered today.
Okay, all right, sure.
Any other questions? If not, well.
Last question.
Last question, okay.
You know, besides the concern, is DCCA here? DCCA. DCCA. Yeah. Thank you, Director. DCCA. You know, the other part of this bill is the insurance mandate, and I don't know, Director mentioned it, but in your testimony you mentioned that there needs to be an audit that's required by HRS 23-51. Just to confirm any kind of, I guess, I would assume economic analysis or outcomes from a bill being passed. Is that something that's required, the auditor?
Our current testimony more so focuses on the subject of ECA defrayment, and then also that there are safeguards in this measure that does speak to a repeal if it does trigger that defrayment. So that's the basis of our testimony.
I'm sorry, I had a hard time hearing you.
Oh, I'm sorry. The basis of our testimony is currently focused on ECA defrayment for any state actions, creating benefits in addition to the essential health benefits. However, we do note that this current version of the bill does have a repeal mechanism in several sections, sections 3, 4, and 17.
So you're saying that because of the repeal mechanisms, that'll safeguard any increase, which doesn't require any audit?
It may safeguard any triggering of a defrayal because of the Affordable Care Act.
It may, but it's not necessarily going to be there. That's an assumption?
It looks like it would be in section 17, 3 and 4. That it is an area that our staff attorney as well as the Department of Health's Attorney Generals did coordinate on.
Okay.
Okay.
Thank you.
Thank you. Thank you very much for all those questions. There being no further questions, we'll go on to the next measure. Thanks to the testifiers for discussing this important matter. Let's move on to Senate Bill 2761. Senate Draft 2, House Draft 2 relating to social media. This measure requires a digital application store provider to verify the age of users, require parental consent for users under 16 years of age to download or purchase or make a purchase on a social media platform and distribute that information to social media platforms. It requires social media platforms to obtain the age information from digital application store providers, determine whether parental consent has been provided for young persons, and take reasonable steps to identify young person users through their algorithms. First up, we have the Attorney General. The Attorney General.
Good afternoon, Chair, Vice Chair, members of the committee. Ashley Tanaka from the Department of the Attorney General. We did submit written comments on this bill, pointing out that this House Draft 2 version of the bill presents greater First Amendment concerns than the previous versions did. In the previous versions, we did testify on the First Amendment risks that those versions posed, but this version, now that it's moved beyond just trying to verify the age of social media users to prevent those under 16 from using social media absent of parental consent, this House Draft 2 is now going to require all, not just social media users, but all application store users, including adults, not just minors, to verify their age, regardless of what kind of app they want to download, not just social media platforms, but any sort of app. Lastly, we did know a recent case from Texas where a similar law was preliminary enjoined by a federal district court in Texas as violating the First Amendment. Thank you. I'm available for questions.
Thank you very much. Raji Tolentino, DCCA Office of Consumer Protection.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Raji Tolentino with the Office of Consumer Protection. We support the intent of this measure and will stand our written testimony offering comments, but I'd like to highlight our concern with the age verification provision of this bill. This provision raises questions about how consumer data will be handled. And in the other states, age verification laws usually limit data collection to what is necessary. They restrict its use and they require deletion after verification. This measure does not clearly include those limits. Without them, it could lead to unnecessary collection of personal information and increase the risk of misuse and data breaches. Adding clear guardrails on data collection, use, and retention would better protect consumers while still allowing the law to work as intended. Thank you for the opportunity to provide comments.
Thank you very much. Amy Boss, Net Choice on Zoom. Please proceed.
Yes, good afternoon, members of the committee. My name is Amy Boss, Vice President of Government Affairs at Net Choice. Respectfully, we are opposed to SB 2761. We share the legislature's concern for children's well-being online, but we believe this bill falls far short. First, this bill is unconstitutional, as courts are already telling us as much. SB 2761 follows the same policy path as Texas App Store bill, which a federal judge blocked in December of 2025. The court said the bill is likely unconstitutional under the First Amendment, finding that existing parental control tools are already allowing families to manage their children's app use without restricting lawful speech. A similar bill is now facing a similar challenge in Utah. That challenge was filed in February of this year. Second, the privacy risks are severe. Age verification data presents a honeypot of sensitive personal information on millions of users, including minors and adults. One data breach could expose the identities and ages of Hawaii's children to bad actors. Protecting kids should not mean building a surveillance infrastructure targeting them. Again, we urge the committee to explore different evidence-based alternatives and oppose this unconstitutional and unworkable mandate. Thank you for the opportunity to testify.
Thanks, Ms. Voss. Next, Michael Kaloyu.
Good afternoon again. Michael Galoya Jr., he, him pronouns. I am president of Pride at Work Hawaii. We stand in strong opposition to this measure before you. You have our testimony. We'd like to focus on things that this legislature should be doing. This bill is not, as some people like to say, not ready for prime time. But we understand what the intent is behind it. Instead of, like the previous testifier said, putting together all this data just right for the picking for a great hacker, hold the social media companies accountable for those that allow them to spread harmful misinformation. That would be a great thing. Strengthen data privacy protections for all users. Another great idea. Invest in digital literacy education to help young people critically evaluate online content. And not just young people, people like those that testified today. It'd be a great idea. So they know what's true and what's not, and so that would be a wonderful thing as well. And finally, ensure any youth safety measures do not isolate or endanger vulnerable populations. Under this current measure, you are asking children to basically out themselves as well if they want to be able to use online platforms when they may not be out, and it may not be safe for them to come out to their parents. I do have to remind you that 40% of our homeless youth identify as LGBTQIA, and that comes from being thrown out of the good Christian families. So this bill is not ready for prime time. There are many reasons that you should and do look at for things for the future, and I encourage you to do so for the next legislative session to help our keiki, to protect them, and not just our keiki, our adults. It's quite clear that there needs to be guardrails on social media. We've seen what happens when there are no guardrails, from January 6th to the measles outbreak, to so many other different things. That social media, but also social media is an area of great, can do some great good, as we saw this past weekend with the marches, bringing people together and finding communities. So this bill's not ready. We cannot support it. We encourage you to hold it in committee, and let's come back next session with something bigger, better, and bolder, and hold Meta, TikTok, and all the other social media platforms accountable, because freedom of speech is free, but you still can't yell fire in a crowded room, and that you are allowed to yell fire on a social media platform today, and there is no repercussions. So thank you and have a good day.
Thank you very much. Robert Singleton on Zoom.
Good afternoon, Chair, Tarnas, members of the committee. My name is Robert Singleton. I serve as the Senior Director of Policy and Public Affairs at Chamber of Progress, a tech industry association that supports inclusive innovation. I'm here today in respectful opposition to SB 2761 as amended because it will mandate intrusive age verification and parental consent requirements at the App Store level, which will undermine privacy, centralize sensitive personal data, and risk cutting young people off from essential online services. So SB 2761 requires app stores to perform account level age verification, effectively forcing the verification of the identity and age of all users, including adults, for every single application, despite the vast majority of apps having no adult content or social media component. Imposing age verification at this level is akin to checking someone's ID before allowing them entry into a shopping mall simply because there's one restaurant that serves alcohol, which also then needs to check your ID. This simply does not make sense, especially when the clear intent of this legislation is to regulate social media platforms, not app stores. And especially so because the largest online app stores already provide a wide array of free and comprehensive parental controls that can be set up at the moment of account creation. So I'll defer to my written testimony for more information, but would just like to highlight that mandatory parental consent requirements risk harming teens in vulnerable or high conflict households. So requiring minors under the age of 16 to obtain verifiable parental consent before they can download, purchase, or make purchases on social media platforms, because access is conditional on parental approval at the App Store level, minors who are unable or unwilling to involve a parent are effectively barred from participating in large portions of the online ecosystem. While parental involvement can be beneficial in many contexts, blanket consent requirements do not account for the wide array of family dynamics and can be misused in high conflict or unsupportive or even abusive households. For example, teens seeking access to mental health resources, LGBTQ+ support communities, or educational tools could be blocked by a parent who is unsupportive or controlling. Research consistently shows that online engagement can reduce isolation and improve mental health outcomes for vulnerable youth, and policies that indiscriminately restrict access risk cutting off these critical lifelines. So for these reasons, we remain opposed to SB 2761. Thank you.
Thank you very much. Andrew O'Connor, the Entertainment Software Association.
Hi, thank you very much. For the record, my name is Andrew O'Connor. I'm testifying on behalf of the Entertainment Software Association. ESA members are the leading publishers and developers of video games in the United States. I'm here to testify in opposition to Senate Bill 2761. I've submitted written testimony and will just take a brief second to go over a few points that echo a lot of the concerns that have come before me. As drafted, the bill is incredibly broad with definitions of app store and social media platform. And would force extensive collection, processing, storage, and sharing of highly sensitive personal information. Even with safeguards that are put around this information, just transmitting this data and forcing a collection of this data when otherwise it may not be collected is highly problematic and substantial privacy and security risks. I think a previous iteration of this bill had put the onus of that collection on social media companies. I would ask that the committee move back to that. And then, of course, I'd be remiss if I did not point out, like others have pointed out, the constitutional concerns around this bill and just the fact that no other state that has passed this has successfully implemented up to this date. So thank you for your time. Happy to answer any questions to my testimony or my written testimony.
Thank you very much. Morgan Stevens, the App Association.
Good afternoon, Chair, Vice Chair, and members of the committee. Thank you for the opportunity to speak with you today regarding SB 2761. My name is Morgan Stevens, and I represent ACT, the App Association, a global trade association for small and medium-sized tech companies and independent app developers. We share your commitment to protecting children online and empowering parents with meaningful tools to manage their children's digital experiences. However, the bill, as currently drafted, raises serious concerns, particularly for small app developers that build general audience products or services. First, the bill's compliance obligations will likely require building new or expanded technical infrastructure to comply and may also trigger additional legal obligations under frameworks such as the Children's Online Privacy Protection Act, even if the app is not designed for or marketed to children. For small developers, establishing and maintaining these systems is costly, complex, and often unrealistic. We are also concerned that the bill may increase privacy and security risks. While well-intended, the bill's approach to age assurance would require additional data collection and transmission, which could introduce new privacy and security risks by design. Finally, the bill raises legal and constitutional concerns. Late last year, a federal court blocked enforcement of a similar law in Texas, finding that it likely violated the First Amendment. We share your goal of protecting children online, and ACT stands ready to work with you on solutions that are effective, privacy protective, and workable for innovators. Thank you for your time and consideration, and I welcome any questions.
Thank you very much. Auden Downey, Computer and Communications Industry Association.
Good afternoon, Chair, members of the committee. My name is Aidan Downey, representing the Computer and Communications Industry Association. While we share the goal of online safety, we oppose Senate Bill 2761. Because it's currently drafted, it faces steep constitutional hurdles and privacy concerns. I don't want to belabor any points. I'm more than happy to echo what my colleagues are saying and sort of stand on the written comment that we submitted last night. But I did want to quickly highlight the constitutional struggles this legislative model has faced, most recently in Texas, which has enjoined a similar mandate. The fiscal impact to defending a bill using taxpayer dollars that's likely to be enjoined is another aspect to consider before advancing this piece of legislation. We respectfully ask for a no vote. Thank you.
Thank you very much. Abby Simmons, Stonewall Caucus.
Hello, Chair, Vice Chair, members of the committee. Abby Simmons, Stonewall Caucus, in opposition to SB 2761. Unless it's amended, we do recognize the hard work of legislators and the intent of this bill. We do share the same goal of protecting youth, but the way that this bill is currently written risks cutting off LGBTQ plus young people from life-saving online support, especially those in non-affirming homes. One good example of life-saving online support is Trevor Space, which is a safe and affirming space that has approximately 700,000 users worldwide that often represents the only safe space available to youth living in fear of violence and harm, including from their own family members. Specifically, the definition of social media platform should be refined to include tangible thresholds such as revenue thresholds. For example, limiting applicability to entities exceeding $100 million in annual revenue, including revenue derived from advertising or the sale of personal data. Meaningful user-based thresholds to ensure that only large-scale platforms are covered. For example, a high statewide user threshold such as 300,000 users in Hawaii or a comparable national threshold. And then finally, to ensure that platforms whose primary purpose is peer support, crisis intervention, or community safety are not unintentionally restricted. So in summary, we respectfully urge amendments to exempt smaller platforms and nonprofit support spaces and to include meaningful revenue and user thresholds so this bill correctly targets large commercial platforms, not safe, moderated communities. If those amendments cannot be made, we do respectfully ask that the bill be deferred. Mahalo for your time.
Thank you very much. David Louie, Meta.
Good afternoon, Chair Tarnas. Thank you for the opportunity. As you know, I'm David Louie. I represent Meta. And we have some concerns that we'd like to bring to your attention. Obviously, Meta shares the goal of the legislature in ensuring a safe and positive online experience for young people. And we appreciate the fact that the legislature has moved forward in changing the original under 16 ban on social media platforms to a framework that would focus on age assurance and parental consent. We think that those are positive steps, and this bill implements an app store level implementation of determining age verification and parental consent. That we believe that is the most effective and the easiest way to do things. However, there are still concerns with this bill because of several reasons, and I'll just put them out on the table. First, there's constitutional issues that exist anytime you deal with social media platforms, because you're talking about regulating content. And as some of the speakers have noted, when you start to regulate content, then you get into First Amendment problems. So the only way around that would be to make this applicable not just to social media platforms, but to all applications, so that it is not just regulating content. I have submitted some potential amendments for your consideration that would do that. Secondly, this bill, and one of the major problems with this bill is this bill requires both age verification and consent at both the App Store and on an app-by-app basis, which is redundant and cumbersome. This is going to become cumbersome because children use maybe 40 apps a week. many times, or 40 apps a day sometimes. And so now every time you have to go to a different app, you have to get a parental consent, or you have to do an age verification. It's super cumbersome. And also, that creates a treasure trove of age data on children, which hackers are just gonna be glomming onto and trying to hack all kinds of platforms. So we just think that would not work in its current form. If the committee decides it wants to move forward with the bill, then we strongly suggest that you adopt the amendments that we have submitted. Thank you very much. I'm happy to take any questions.
Thank you, Mr. Louie. Is there anyone else wishing to testify on this measure? If not, questions, members?
Mr. Chair.
Rep. Garcia.
Former AG Louis, thank you for being here. Good to see you again. I think I had some questions in the previous committee on this bill, and it was amended. And I do think some of the amendments does make the bill significantly better. However, is it your understanding still, sir, that this bill as written in this House Draft 2 is still a violation of the First Amendment?
I believe so, yes, it is subject to that kind of challenge. I think the Attorney General has noted that in their comments. And the problem is it is regulating and targeting social media platforms about content. So yes.
Okay, thank you very much.
Thank you very much, Representative.
Okay. Further questions? Let's move on to the next measure. Thank you very much. Senate Bill 2387, Senate Draft 1, House Draft 1, relating to digital financial asset transaction kiosks. This measure establishes limits on transactions through digital financial asset transaction kiosks. Prohibits the exchanging of US currency from new customers for digital financial assets. Any two customers from transacting to the same digital financial asset wallet address. And prohibits beginning January 1st, 2030, the exchange of US currency from customers for digital financial assets. Requires operators of digital financial asset transaction kiosks to use blockchain analytics and tracing software to prevent fraud, make certain disclosures, provide receipts to customers, provide full refunds under certain circumstances, and provide live customer service and a dedicated communications line for the Attorney General, Office of Consumer Protection, Department of Law Enforcement, and county police departments. First up, we have Hawaii State Council on Developmental Disabilities. Oh, okay.
Aloha Chair, committee members, my name is Jay Silver. I'm with the Hawaii State Council on Developmental Disabilities. I'm here for Danger Bartolus, our Executive Director. Happy April Fools. In April Fool's essence, we accidentally gave you an old version of our testimony. Yeah.
Already made your amendment.
I was debating about making a really bad April Fool's joke, but I wasn't quick on my feet. So essentially, we apologize for our old draft. The amendment is already in the bill. We appreciate that the bill is preventing fraud and our population would be subject to that. And plain language is always the best practice when trying to communicate information clearly. Thank you so much.
Thank you, Shay. Always good to see you. Next, Emma Olson, DCCA Office of Consumer Protection, or designee.
Thank you, Chair, Vice Chair, members. My name is Mana Moriarty. I'm the Executive Director at the Office of Consumer Protection. We appreciate the amendments that the prior committee made, which I think added some new protections to this bill that make the protections more robust in our opinion. In particular, I want to just flag for you the 7-day hold period for new customers, which is contained in the definition newly inserted of the new customer. We think that's an appropriate definition at this point as drafted. We're not aware of concerns with that particular definition. We also appreciate the provision sunsetting the ability to transact with these digital financial kiosks in the year 2030. That's an important protection that's been inserted by the previous committee. And before I conclude, I really want to flag for this committee's consideration that the most important perhaps consideration in here, protection, is that full refunds would be given to customers who report a fraud to law enforcement. That is substantial, and we urge you to keep that in this bill because full refunds, they'll have a cascading effect. Right now, we have strong concerns, grave concerns expressed in our testimony that this industry is the source of frauds and scams that have really affected Hawaii's population. By requiring them to give full refunds when reports of scams are given to law enforcement, it will effectively help to weed out the operators who do not have effective fraud controls, because companies that are required to give full refunds in response to fraud will not be able to keep hemorrhaging money due to the reported frauds. They will eventually be forced to withdraw their business from the state of Hawaii. And I think that is an appropriate consequence of a failure to implement effective fraud controls. So we urge you to keep that in. At this point, we are urging the committee to pass the bill out of this committee as is, and we're happy to address questions if the committee has them.
Thank you very much. Next, Louise Myers with Hilt Ventures on Zoom. Please unmute yourself.
I'm on mute, I see that. So, good afternoon, Senator Tarnas and members of the committee. Louise Hayes Myers with Hilt Ventures. We stand by the testimony that was submitted, and right now I'd just like to take a moment to address some common misconceptions that you have read and may hear today regarding crypto kiosks and providing important context. The fact is the number of crypto kiosk scams pales in comparison to the number of cryptocurrency fraud occurring through other platforms like online exchanges, Coinbase for instance, or cash to crypto counter services, yet this bill only focuses on crypto kiosks. The fact is the FinCEN advisory attached to testimony is not a statement by FinCEN that crypto kiosks are bad. What it states is that non-compliant operators are a major driver of kiosk-related scams, while compliant operators like Hilt can help detect and stop fraud. I want to point that out because, and especially in light of what the representative from the Attorney General's office just said, the fact is that 100% of scams are first-time users with no prior crypto experience. And that's why effective balance laws that differentiate between new and existing customers, where tighter standards are applied to the newer customers with higher limits applied to existing customers makes sense. This has been recognized in almost every state that has refund and transaction limit provisions. I think we've included a lot of those in our testimony already, but I'd encourage the committee to take a look at those laws. They do differentiate between new and existing, and it's because first-time customers are where the scams happen. These people have no prior crypto experience. These laws have proven to be effective. And an example that has been provided is in Arizona, where it is documented in news articles and by the AARP themselves that it has been effective in limiting scams and having fraud victims get full refunds. We do stop crimes here in Hawaii. We have a sophisticated software to do so. But these are first-time customers where the scams are happening. It's not, the way this bill is written right now, refunds are open-ended. It's in perpetuity. There is no set deadline like there is in all these other state bills where a new customer would have, 30, 60, whatever, 90 days to report. This one's open-ended. And existing customers are not where the scams are happening. We can show this by facts. We've been operating here for several years. We stop our scams. We have police reports. We have customers that can come forward, law enforcement that will come forward to corroborate this. So I just, we're here to answer any questions and appreciate the time.
Thank you very much. Next, AARP Hawaii.
Good afternoon, Chair, members of the committee. I'm Audrey Suga Nakagawa. I am with AARP Hawaii, and we stand in strong support of our testimony. AARP appreciates the committee and legislators' continued attention to protecting consumers, especially in this rapidly evolving cryptocurrency industry. And we really do recognize the House efforts to address the immediate consumer risks, especially to new customers. And we're not opposed to cryptocurrency, but what we are very concerned about is how these crypto kiosks are being used as very accessible tools to defraud customers. And just this morning, and this is not an April Fool joke, just this morning I got a call from a Big Island resident in Kiao who shared a story that she nearly lost $25,000 last month to a fraudster. And this fraudster, without going into how this all got set up, this fraudster actually directed her to a very specific convenience store in Hilo and even told her how to explain to the bank teller why she's withdrawing $25,000. He said, tell her that you're going to Vegas. And while her son was trying to stop her, she was already coached as to what to tell her son about why she's doing this. And then the only reason why she didn't lose her money was when she was at that store, kind of struggling to put all that money into the kiosk. A bystander said, "What are you doing?" And then she said, "I think this is a fraud. This is a scam. Stop right now." And that's how she saved her money. She was saved by not losing $25,000 of her life savings. So this is the kind of examples why ARP is standing really in strong support of this type of legislation. And we look forward to seeing this bill pass and going to conference. There is HB 1642 that's also being scheduled to be heard by the Senate. We're hoping that the both bills come to conference so that we can reconcile the small differences. I think that both bills are pretty aligned now. And we look forward to working with the legislature, the stakeholders and the regulators to ensure that a very strong bill is passed out that will protect Hawaii's consumers. Thank you.
Thank you very much. Next, Chip Myers on Zoom.
Afternoon, Chair and committee members. Thanks for allowing me to speak. First of all, I'd like to respond real quickly to the ARP representative. That potential scam of $20,000 would never, ever be possible at a Hill kiosk. We have one in Hilo. You can't stick $20,000 into the kiosk. So we have lots of safety measures in place. The most that potentially they could stick in there for a first-time user would be $1,800. So she was never in risk of losing $20,000. I just want to make sure people understand these things because there's a lot of hysterics and a lot of talk about things, but no facts. We have the facts. So what I would like to say is I want to call attention specifically to items in the bill proposed that are not routine consumer protection measures. They raise serious fundamental questions of civil law due process and statutory clarity that squarely fall within the purview of your committee. This bill creates an open-ended perpetual right for any customer, new or long-term, to demand a full refund with no time limit after discovering the alleged fraud. This imposes an extraordinary indefinite civil liability on private operators that has no counterpart in Hawaii law or other financial service businesses. By burdening one class of business with unique civil restrictions and liabilities while leaving comparable cash handling industries unregulated in the same manner, it raises serious constitutional and civil law concerns regarding arbitrary classification and unequal treatment and under the law and the proper balance between individual consumer rights and legitimate business operations, which HILT is. Moreover, the new customer definition and prohibition added by the latest amendment contain a core drafting defect that renders part of the bill internally inconsistent and practically unworkable. It prohibits operators from accepting cash from new customers in exchange for digital financial assets. Yet at the same time, it tries to create rules that apply differently to new customers versus existing customers. If a person has never transacted with that kiosk operator before, they are by definition a new customer. But the bill bans new customers from making any cash to crypto transaction. This creates a catch-22. I mean, how can someone ever become an existing customer if they are legally prohibited from completing their very first transaction? It makes no sense. Additionally, the bill caps existing users 2,000 per day, 10,000 per month, but imposes no restriction on phone apps, online platforms that people can also purchase crypto from, and then make up 15 times what the amount of scams are that happen at kiosks. This creates an arbitrary discriminatory classification between two otherwise identical forms of lawful commerce. Purchasing cryptocurrency with cash at a physical kiosk versus purchasing it on your phone or computer, which anybody's going to be able to continue to do, kapuna, including myself. By imposing indefinite restrictions on repeat customers without a rationale relationship to preventing fraud, since these customers have already established a verified relationship with us, This bill violates substantial due process, raises equal protection issues by treating situated businesses and consumers differently based on solely the method of transaction. And lastly, the amendment had a total ban effective in 2030. This differential treatment fails even the most deferential, rational basis under the Equal Protection Clause. There's no rational relationship between the government's interest in preventing fraud and a total ban on kiosks when the exact same risks will continue unregulated on phone apps, online platforms that handle vastly larger transactions. A law that treats similar situated economic activity so differently is presumptively arbitrary and violates equal protection. So the issues of statutory clarity, logical consistency, due process, and the proper drafting of civil liabilities and individual rights, these all need to be resolved before this bill can move forward. I appreciate your attention to this, and thank you for the time.
Thank you, Mr. Myers. Next, Hawaii Bankers Association. Either Tiffany Yajima or Mihoko Ito? Nope, not present. Anyone else wishing to testify on Senate Bill 2387?
Chair.
Mr. Masakia?
Thank you very much. Aloha again, Chair, Vice Chair, and members of the committee. My name is Greg Masakian, and as I mentioned earlier, I'm a Kapuna advocate in the state of Hawaii. I'm strongly opposed to these kiosks. I do understand and have heard stories about, not just in Hawaii, but throughout the nation with research that I've done about adverse results when Kapuna go to these machines. They don't understand what they're doing, and they're instructed to do certain things, or they just maybe even experiment with things. But in any event, there's harmful effects that we know. I'm from the era of born in the 60s, and I'm from the era of banking as you go to the bank, and I do understand we're in a different world now, and I accept that. But with the generation that we're in, the younger generation, and the need for the cryptocurrency, which just seems to be a desirable thing, I think there needs to be extreme regulation. And I think Hawaii has the right to dictate what that regulation is. So what I will say now is, if you have an opportunity to amend this bill, I would just ban all kiosks completely from the state of Hawaii. And I know that there's at least one state that's doing that and one that's proposing it. So with that said, I would ask to get rid of the kiosks, and for the sake of Kapuna and just for the sake of doing things, maybe the old-fashioned way, but the best way. So mahalo for that opportunity.
Thank you. Anyone else wishing to testify on this measure? If not, questions, members? If not, yes, Rep. Garcia?
For AARP, please. Thank you for being here, and we met earlier, I believe, at the beginning of session, and went over some of your priorities. Is it your understanding that the part where it bans any acceptance of US currency was not part of the original bill or the original draft?
Yes, it wasn't in the original.
Okay, I just was curious about that. Thank you very much.
Okay.
Thank you, Chair.
Sure. Okay, any other questions? If not, we'll move on to the next measure. Thank you very much to the testifiers. Senate Bill 2765, Senate Draft 1, House Draft 1 relating to condominiums. This measure clarifies that condominium associations that have obtained title to a unit through foreclosure may retain rental income received prior to the appointment of a commissioner in a subsequent foreclosure, but the association may be required by a court to remit rental income received after the appointment of a commissioner to be held until an order of distribution is entered by the court. First up, Dallas Walker, Community Associations Institute. On Zoom, not present. Next, Hawaii Bankers Association, either Mihoko Ito or Tiffany Yajima. There's Mihoko Ito. We're on Senate Bill 2765.
Yes, good afternoon, Chair and members of the committee. Mihoko Ito on behalf of the Hawaii Bankers Association. We are respectfully opposed to this bill for several reasons. First, it really actually upsets long-standing lien principles which require payment from senior to junior mortgages. Instead, what this bill proposes to do is to take the rental proceeds after a condo has foreclosed and there's a subsequent foreclosure and just straight give that money back to the condo association. So we are opposed for those reasons. We think that if passed, that it would have a substantial impact on lending criteria from a bigger picture perspective. And for those reasons, we'd ask you to defer the bill.
Thank you.
Thank you very much. Paul Ireland Cloftino in Zoom.
Good afternoon, Chair, Vice Chair. Can you hear me?
Yes, please proceed.
Okay, I support this measure. I think it's very unfair as a condominium unit owner and as an attorney who's involved in these cases to require associations to disgorge a portion of their rental income to a senior lien that is already foreclosing on a property where it has usually, in most cases, substantial debt that's owed to the senior lien. In most of these cases, there is not going to be excess rental income because the association can barely cover the through the rent the debt that's owed to the association through the rental proceeds. But in those cases where there may be excess rental income or excess rental proceeds, that money is applied to the senior lien. And it's very rare in cases where a senior lien is foreclosing, where they wouldn't bid up to the full amount of the debt and would actually have a case where they're seeking a deficiency judgment against the owner. So this is a very smoke and mirrors way for mortgages to essentially disgorge rental income that an association should be able to keep under, and they really aren't entitled to it. They shouldn't be entitled to it. So this statute, as it presently stands, was created to disadvantage associations, and this practice needs to stop. It ends up in needless litigation, and the association owners need a break. So I'd ask for your committee to support this measure, pass it, so it can go to conference.
Thank you very
Thank
much.
you.
Greg Masakian?
Aloha again. Thank you. Greg Masakian here. I am a condo owner and I'm a director on my condo association's board. And I have familiarity with this issue with what I believe from historical records that I don't have complete because they were from a while back, but there were non-judicial foreclosures and a couple of units that we took possession of as the association. What my concern is, and there are two, and I'm just going to briefly state them. The way this bill is written is concerning. One, which the Hawaii Bankers Association and the Mortgage Bankers Association of Hawaii clearly defined in their testimony regarding priority of lien holders with established precedent in Hawaii. There is already an allowance for HOAs and associations to recover some unpaid maintenance fees ahead of the first mortgagee. This bill, in my opinion, would create the potential for more legal issues and costs going forward for all parties, which includes associations, mortgagees, and owners. The second reason this bill is not a good bill is the reference to non-judicial foreclosures, which can be challenged and often are. The dynamics of the lien holder priority concerns, together with the dynamics of a possible non-judicial foreclosure, are a recipe for one thing: further harm to the owners or former owners who still have debts to resolve with their mortgagees, and potential for court challenges and litigation, which will add a burden and additional cost to the association. So with that said, I strongly oppose this bill as written. I do believe there's some need to make associations whole if they somehow take title, but if the mortgagee is interested in title or foreclosure, then there should be a better process for the foreclosure process. And I believe it should always be judicial and never non-judicial. Mahalo.
Thank you very much. Anyone else wishing to testify on this measure? If not, questions, members?
I have a quick question, just
Yes.
one question to Mihoko. Do you know if there are any other states that have this process? If this bill passes, would any other state have this kind of precedent where the lien rights are bypassed?
I could look into that for you. I don't know offhand, but I do know that every state has, a system where senior mortgages get paid first, and then, subsequent lien holders get paid after. So that is a longstanding principle. It's in Fannie and Freddie documents. It's in the mortgage documents that there's a security interest in rental proceeds. And that's pretty standard across the board. But I don't know if any other state has tried to do this specific proposal.
Okay, thank you.
Sure.
Thank you, Chair.
Thank you. Any other questions? If not, we'll move on. Thank you to the testifiers on this. Let's move on to the next measure. Senate Bill 888, Senate Draft 2, House Draft 1 relating to consumer protection. This measure prohibits operators of smart household security devices from sharing user data with law enforcement agencies unless the user consents. The law enforcement agency obtains a judicial warrant, or there is an emergency situation involving a clear and present danger of imminent death or great bodily harm. The measure prohibits operators from requiring users to consent to share data with law enforcement agencies to use a smart household security device. On this, first up, DCCA Office of Consumer Protection.
Good afternoon, Chair Tarnas, members of the committee. My name is Melissa Enright. I'm with the Office of Consumer Protection. We stand on our written testimony with comments. I would just briefly note that law enforcement, as it stands now, cannot enter our homes without a judicial warrant, absent exigent circumstances. This bill essentially does the same thing, but in a digital way. It requires that law enforcement, before they enter digitally into the sanctity of our homes, obtain a judicial warrant first, or it also provides for the legitimate needs of law enforcement in an emergency circumstance where there is an imminent threat of death or serious harm. We do think it appropriately balances the privacy rights of citizens with the needs of law enforcement. Thank you.
Thank you very much. Is there anyone else wishing to testify on this measure? If not, questions, members?
I'm sorry, Chair.
Yep. Go ahead,
Were you
Rep.
support?
Shimizu.
Were you in support or opposition? I'm sorry.
We offered comments.
Okay. And where were you from again?
Office of Consumer Protection.
Department of Commerce and Consumer Affairs. Okay, anything else? If not, let's move on to the last measure on our agenda. Senate Bill 3001, Senate Draft 2, House Draft 2 relating to artificial intelligence. This measure requires operators of conversational artificial intelligence services in the state to issue certain disclosures to account holders and users. Requires operators to develop protocols to prevent the production of suicidal ideations in account holders and users. Establishes protections for account holders and users of conversational artificial intelligence services. Establishes protections for minor account holders and users of conversational artificial intelligence services. And beginning January 1st, 2028, requires operators to submit annual reports to the Department of Commerce and Consumer Affairs containing certain information, and allows the Department of Attorney General and Office of Consumer Protection to bring a civil action against operators who violate certain requirements, and establishes that violations are to be considered unfair or deceptive acts or practices. First up, we have the Attorney General.
Good afternoon, Chair, Vice Chair, members of the committee. Ashley Tanaka from the Department of the Attorney General. We support the purpose of this bill, and we did offer comments regarding recommending deletion of a redundant phrase, and as well as recommending definitions for terms that currently aren't defined to further strengthen the bill. Thank you. Available for questions.
Thank you very much for noticing those. Next, Department of Education, support. Not present. Next, State Health Planning and Development Agency.
Hello, good afternoon. Thank you, Chair, Vice Chair, and members of the committee. Terry Visperis on behalf of Jack Lewin SHPTA. We'd like to stand strong support of 3001 SD2, HD2 with comments. And again, just the basic is that we really want to, it improves transparency, strengthens protections for children, and sets clear expectations for the crisis situation and holds these companies accountable.
Thank you very much. Raji Tolentino, DCCA Office of Consumer Protection.
Good afternoon again, Raji Tolentino. We will stand on our written testimony and offer comments, but I'd like to highlight one requested amendment on page 2, lines 20 to 21, subsection C3. The bill includes a knowingly or intentionally standard. This raises the burden of proof beyond Hawaii's UDAP law, which does not require intent, and that would make enforcement more difficult for us. So we recommend moving the language knowingly or intentionally. Operators should simply not cause a service to represent that it provides professional or mental health or behavioral health care. Thank you.
Thank you very much. Next, Young People's Alliance, Mike Tobin on Zoom.
Aloha, Chair Tarnas, members of the committee. My name is Mick Tobin. I am 23 years old and the co-founder of the Young People's Alliance. We're a youth-led bipartisan organization representing 2,800 students across 72 campuses nationally. I want to use my time to reiterate a few key points from my written testimony. First, I noticed SB 3001 when I flew to Honolulu to testify in support of a somewhat similar and much stronger competing bill, HB 1782, 3 weeks ago. I was concerned by SB 3001 because it was missing some key protections that HB 1782 included and used verbatim text from bills we've seen introduced by big tech companies across the country to protect them from actual enforcement. But thankfully, as this bill has moved through the House, committees have adopted some of HB 1782's strong protections, including the addition of limitations against manipulative design techniques that foster emotional dependence, and that's what is now Section 2D of SB 3001. And I respectfully urge the committee to keep these protections in the face of any proposed amendments that might try to take these out, and to continue amending SB 3001 with HB 1782's stronger language to ultimately protect children. First, HB 1782 includes an age assurance provision. As written, SB 3001's protections for minors only apply when a chatbot company has reasonable certainty that a user is a child, but the bill never requires the operator to estimate age. So a company that chooses not to estimate age could just claim that it never knew, and every minor-specific safeguard in the bill would just not apply. Technology companies or chatbot companies already have the tech to estimate age, so I think this should be mandatory. And then also HB 1782 includes the private right of action, and SB 3001 doesn't. And without one, we're essentially telling harmed families that they have no way to actually hold these companies accountable, and we're placing the entire enforcement burden on the AG's office. And there's numerous other bills that I've listed in my testimony that you have a PRA, and I think this bill should as well. And then last quick note is that there is a $1 million cap per operator violation in subsection G2B, and I just think that's pretty low for a major tech company, right? Like, this cap essentially, right? Like, it's nothing to Meta or Google, and so they can treat that as rounding error. Versus HB 1782, it has a $15,000 per day per violation with no cap, which means that liability grows the longer a company is out of compliance and scales the number of affected children users. So I'll look for your consideration, and great to see you all again.
Thank you very much. Jai Simha, Transparency Coalition on Zoom.
Thank you, Chair and members of the committee. My name is JHA Simha. I'm testifying in support of SB 3001 with some amendments. As the co-founder of Transparency Coalition, we're an independent nonprofit which advocates for increased transparency and accountability in generative AI. In this session alone, in this year, we've been working to ensure the passage of next-generation chatbot legislation in over 20 states. I'm also pleased to report that just today, the governor of Oregon recently joined the governor of Washington in signing into law carefully crafted chatbot laws. And there's several opportunities with SB 3001 to improve the bill and bring it in line with these other ones. For one, chatbot laws in California, Washington, and Oregon all provide for a private right of action for citizens to obtain redress when affected by chatbots in a material fashion. Why should Hawaii's residents receive less protection in these other states? Tech was actually neutral on these provisions in all three states. As a former tech employee involved in defining and developing new products at companies like Amazon and Microsoft, I can tell you that potential legal liability is a major consideration when deciding between potentially expensive safety or privacy-related changes and choosing to test the product on your children. At a minimum, we request you to remove the language that eliminates rights that might already be available to Hawaii's residents in the existing law. For example, the bill includes language that, as Mick mentioned, caps liability, but there's also language that says you can't pursue liability even if you had other protections that already existed. So this bill will actually remove protections as opposed to add to them. The other thing that SB 3001 also does is uses the knows or reasonable certainty language. Under this standard, an operator that's never asks users their age and ignores contextual signals could possibly claim it never had reasonable certainty. For example, if a user's language, behavior, or content patterns strongly suggest they're a child, an operator could still claim ignorance just because the user never explicitly disclosed their age. We recommend using a broader standard, such as should reasonably know in the course of business. And also in my written testimony, I have offered a broader definition of the term knows, which would also stand and cover a broad range of scenarios that work well for operators. Thank you again for hearing this bill, and we hope to work with you on amending this important piece of legislation and supporting it through passage. I'm available to answer any questions.
Thank you very much. Chris Caulfield, MO Alliance. Not present. Next, Aiden Downey on Zoom.
Chair, members of the committee, I'm Aiden Downey representing the Computer and Communications Industry Association. While we support protecting child safety online, we respectfully oppose SB 3001 in its current form and propose 2 critical amendments in our written comments. First, the bill's definition of conversational artificial intelligence is overly broad and creates significant compliance uncertainty. We urge the committee to revert to the definition from the HD1 version, which provides essential exemptions for low-risk tools like research applications, internal business software, customer service bots, and other tools of the like. Second, we recommend narrowing the definition of minor from under 18 to under 13. This aligns the bill with federal COPA standards and ensures that teenagers can continue to access the digital resources they need for school and personal growth without unnecessary restrictions. Thank you for your consideration.
Thank you very much. Nahe Parsons, representing Google.
Mahalo, Chair, Vice Chair, members of the committee. Nahalani Parsons here on behalf of Google in support of this measure. Just want to thank the committee for hearing this. There's nothing currently in statute that regarding conversational AI and chatbots. And speaking to the Department of Health testimony that mentioned that although this may not address all the concerns, it does provide an initial framework, and that's really what we appreciate the committee looking at today. My testimony specifically has 2 amendments in there that are much to what the other testifiers mentioned about regarding putting in the exceptions to conversational AI to exclude things like customer service, as well as deleting on page 3, section B, that goes back to sort of the core content of what was in the HD1 originally. Recognizing that this may be a conversation for a conference, we respectfully ask the committee to move this measure forward so we can continue this conversation. Thank you, and available if you have any questions.
Thank you, Ms. Parsons. Brianna Harmon on Zoom, not present. Andrew O'Connor on Zoom. Please proceed.
Thank you. For the record, my name is Andrew O'Connor. I'm with the Entertainment Software Association. We represent leading publishers and developers of video games in the United States. Our opposition to this bill is not anything to do with the underlying goals of the bill. It's merely around inconsistency with other state laws. There's been reference to California, Oregon, and Washington. All of those states exempted in-game chatbots from these bills, kind of an unintended consequence of the writing of this definition for a companion chatbot. I'm happy to provide the committee with that language for those. Chatbots and other similar technologies have long been incorporated into video games and play an integral role as interactive non-player characters that enhance the gameplay and storytelling. As such, they do not present the same sort of risk that a companion chatbot, as I think the committee is trying to target with this legislation, does. They're best understood as interactive characters with a narrative experience, not an AI companion standalone to simulate personal relationships or give advice or anything of that sort. They're simply part of the story and world building of the game. Further to that, the Entertainment Software Ratings Board provides parents with comprehensive information around the content of a game and has parental controls that can set boundaries around any types of games or experiences their children can access. Happy to answer any questions. Thank you for your time.
Thank you very much. Anyone else wishing to testify on this measure? If not, questions,
Chair?
members?
Oh, Chair, from Zoom, sorry, I was a little late getting to
Mr.
the
Misakian, you have a comment on
last
this one
one.
too, huh? You can't help
I'll
yourself.
wrap it up for the committee, so thank you. Just a
Go
very quick
ahead.
comment, if you can
You're
give me
the last
the chance.
person to testify, so we're eager to hear you, so we can move on.
Mahalo. I support this bill, and I support it with the very well thought out amendments that I've heard. I did read some of the testimony that I've heard and read from all of the testifiers today. So I hope that this committee allows time to let this cook and stew properly. So when it's in its final version, it will be properly out there. But it's absolutely something that's needed. I'm watching too many investigative TV shows and issues where these chatbots and these things are resulting in the deaths of many young people and people in general that are unfortunately committing suicide because of them. So with that said, not to end on a bad note, but that's part of the issue that needs to be addressed. So aloha, thank you for your time, and thank you for all you did today. Mahalo.
Thank you very much, Mr. Misakian. Anyone else wishing to testify on this measure? If not, questions, members? If there's no questions, we will move on to decision making. Thank you very much to all the testifiers and all the bills today. Let's move to the top of the agenda. Senate Bill 3322, Senate Draft 2, House Draft 1. We moved out House Bill 2540, House Draft 2 from this committee before. I would urge that we do the same that we would insert the language from House Bill 2540 HD2 into this, but also I want to amend it slightly on page 12, lines 1 to 11. I want to delete that, just those sections. And it's just because that language is duplicative of another section of the bill, so I wanted to clean it up. But in essence, it's Senate, we're gonna be putting into this bill, House Bill 2540, House Draft 2, with that one section on page 12, line 1 to 11 removed. Questions or concerns, members?
Comment, Chair.
Sure.
Thank you, Chair. I just wanna say, first of all, I am gonna vote no on this bill, but during the testimony, one of the testifiers, which has a record of disparaging other testifiers, said that ICE is a terrorist organization. I think that should be called out. These people, people might not agree with what they're doing, but they're simply employees of the federal government. They're following orders and they're enforcing federal immigration law. If what they're doing is terrorist acts, then go talk to Congress about that, because they're enforcing federal immigration law. So I think that statement should be called out, but at the end of this, no vote. Thank you.
Yeah, and I did try to make sure that when he spoke again, that I tried to focus his attention on it. So I'm trying my best. Thanks very much for that reminder. Any other comments or concerns?
Chair.
If yes, Rep. Shimizu.
Thank you, Chair. I will also be voting no. I would like to see Hawaii County Police Department's testimony where we would refer this to the Law Enforcement Standards Board. That would be a more appropriate place where comprehensive standards could be worked on and agreed upon. And also Shopo's testimony regarding the real life experience of a law enforcement officer having to use masks at times. So I think it's good intentions, but the bill just is not comprehensive in a lot of ways. So I'm gonna be voting no.
Okay. Other comments?
Yeah, Chair.
Rep. Cochran?
You did mention that you're going to be removing some redundant verbiage.
Yes.
Okay, and so any attempt to add in any other types of amendments such as legal affairs, Jan Govea from UH at all? Did you entertain any of that language from her? Okay. With that, I was hoping that more amendments would have been made and I would be supportive, but at this time, no.
Okay. Other comments? If seeing no other comments, Vice Chair for the vote.
Voting on SB 3322 SD2 HD1 with amendments. Chair and Vice Chair vote aye. Representative Bellotti.
Aye.
Representative Cochran.
No.
Representative Hashem is excused. Representative Kahaloa.
Aye.
Representative Sayama is excused. Representative Takayama.
Aye.
Representative Garcia.
No vote.
And Representative Okay, recommendation is adopted.
Thank you. Senate Bill 2090, House Draft 1 relating to child custody. I recommend we move this out as is. It has a defective date, so it won't go to conference. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2090 HD1 as is. Representatives Hashem and Sayama are excused. Are there any voting no? Any with reservations?
Reservations.
Reservations for Representative Garcia. Recommendation is adopted.
Thank you. Senate Bill 2108, Senate Draft 1, House Draft 1 relating to jurisdiction. I'd like to move this out with technical amendments for clarity, consistency, and style. And also adopt the recommended amendment from Ms. Komonos in their testimony saying that only children 14 years of age or older may be waived into adult court. And we put that into section 571-22 subsection D. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2108 SD1 HD1 with amendments. Representatives Hashem and Sayama are excused. Are there any voting no? Any with reservations? Recommendation is adopted.
Thank you. Senate Bill 2325, Senate Draft 1, House Draft 1 relating to juvenile offenders. Considering the judiciary testimony and other testimony, I think this bill does not really do what it was hoping to do. I think we should defer the bill. I think we need a different bill that is going to be much more complicated because we have a indeterminate sentences structure. We need a different bill that would change the indeterminate sentencing, which is something we have in Hawaii, which is not something that other states have, but we do. And I think the suggestions from judiciary about perhaps giving some of this responsibility to the paroling authority merits a consideration, but this bill is not ready. So I recommend we defer this. Comments or concerns?
Thank you, Chair, for that decision.
Okay, thank you. Let's move on to the next measure, Senate Bill 2408, Senate Draft 1, House Draft 1. Nobody likes this bill. It's not really doing what I think it was originally intended to do, and it's taking a national sort of model and trying to apply it here, and it isn't working elsewhere, and I don't think it's gonna work here. So rather than try to rework the whole thing, we should try again with something different next year. So I recommend we defer this measure. Comments or concerns? Thank you. Next measure. Senate Bill 2418, Senate Draft 1, House Draft 1, relating to controlled substances. On this one, I would like to make 2418. On this one, we need to make a change in here because it's rather confusing language. Page 7, line 11, page 11, lines 5. We need to delete references to sections that have already been repealed. The way this bill is written, it's referring to different sections that have been repealed, and that doesn't make sense. So we need to delete those references to sections that have been repealed. And the use of the term drug paraphernalia in sections 329-43.6 and 329-55 looks like it could also be repealed, and then the definition in 329-1 could also be repealed. So it just needs to be some cleanup in this to make sure that it's clear as we move this forward. So with those changes and let's say technical amendments for clarity, consistency, and style, I'd like to move it forward to conference. Questions or concerns, members?
Comment, Chair.
Yes.
Thank you, Chair.
Garcia.
Thank you. I just wanna say I oppose this bill. I think it's important to note that the people who are on the front lines of law enforcement who deal with drug activity and criminal activity in our communities oppose this bill. The Attorney General opposes this bill, the prosecuting attorneys from Hawaii County oppose this bill, Honolulu Police Department opposes this bill. I think, and I agree with them, that this is bad policy, so no vote.
Okay.
Chair, ditto.
Rep. Shimizu, ditto. Okay. Any other comments? Vice Chair for the vote.
Voting on SB 2418, SD1 HD1 with amendments. Representatives Hashem and Sayama are excused. No votes for Representatives Garcia and Shimizu. Any additional no votes? No for Representative Cochran. Any with reservations? Recommendation is adopted.
Thank you. Senate Bill 3133 relating to preventive medicine. On this, I would like to move it forward with technical amendments for clarity, consistency, and style. That's it. Questions or concerns, members?
Chair,
Rep. Shimizu?
I'm gonna be voting no on this.
Okay. Other comments? Not. Vice Chair for the vote.
Voting on SB 3133 SD2 HD2 with amendments. Representatives Hashem and Sayama are excused. Are there any voting no in addition to Rep. Shimizu? Representative Cochran?
No vote.
No for Representative Garcia. Any with reservations? Recommendation is adopted.
Thank you. Senate Bill 2761 relating to social media. I've got there's some real constitutionality concerns with this. I think we need to take a different approach, so I recommend we defer this measure. Questions or concerns?
Comment, Chair, I would agree with that. I agree with that. I think it was a very flawed bill, and the violations of the First Amendment is a serious violation, so thank you for your deferral.
Sure. Any other comments? Okay, thank you. Let's move on to the next one. Senate Bill 2387, Senate Draft 1, House Draft 1, relating to digital financial asset transaction kiosks. I would like to move this forward. It does need to go to conference. It needs some more work, but I think it is worthwhile pursuing. On this one, we need to do we need to clarify that when a customer receives a refund while also retaining the digital financial asset associated with the transaction, the customer must return any digital currency after the full issue is refunded. So I need to put language in there to clarify that. On page 2, lines 3 to 5, we need to amend the sentence to read, quote, accept US currency by cash, credit card, or any other means in an amount greater than $100 from a new customer in exchange for digital financial assets. And we should spell out US, so accept United States currency by cash, credit card, or any other means in an amount greater than $100 from a new customer in exchange for digital financial assets. So new customers would be able to have an initial transaction. And then on page 2, we need to move subsection 4 to a new section. It should not be there, so it's gonna, we're not gonna delete it, we're just moving it to a new section, so it'll stand on its own. Those are my recommendations and technical amendments for clarity, consistency, and style. Questions or concerns, members?
Question, Chair.
Sure.
Are you amending it, cause the current language would prohibit any acceptance of US currency, so you're changing that?
I'm saying that if for new customers, they can accept US currency only up to $100.
Only up to 100?
Yeah.
Okay. Alright, thank you.
Chair, I have a comment. You know,
Shimizu?
this is one of those bills like many that there's pluses and minuses. I have concerns with the bill with, you know, free enterprise and business, but when I have to consider protecting the kupuna, I have to go with that, so I'm gonna be voting yes with reservations.
Chair, a second comment.
Yes.
The bill originally written, I very much support. I wanna thank AARP for being here and pushing this. The original intent was to protect seniors from being scammed by setting a threshold of how much cash can be deposited. It's evolved throughout the session, and so I do wanna support it, but I do have some reservations, so like Rep. Shimizu with reservations.
Okay, understood. Other comments? If not, Vice Chair for the vote.
Voting on SB 2387 SD1 HD1 with amendments, Representatives Hashem and Sayama are excused. Any voting no? Reservations for Representatives Garcia and Shimizu. Any additional reservations?
And Cochran.
Reservations for Representative Cochran. Any additional reservations? Recommendation is adopted.
Thank you. Senate Bill 2765, Senate Draft 1, House Draft 1, relating to condominiums. I'd like to move this out as is. It has a defective date. It will have to go to conference, so if we see any more changes, we still have opportunities to do so, but I'd like to move this out as is. Questions or concerns, members?
Chair.
Yep, yes.
I'm gonna be voting no on this because I think the banks have a great point and we need to respect their lien rights, so I'm gonna be voting no.
Okay, other comments? If not, Vice.
Chair.
Yes.
Sorry, probably with reservations and to see what transpires through conference. I'm just curious how this affects the Lahaina people and, you know, their condos and losing and destroying. Anyways, I'm just,
Okay.
this is above my pay grade sort of, so I
Okay.
just wanna see where it falls through conference. Thank you, with reservations.
Okay, any other comments? If not, Vice Chair for the vote.
Voting on SB 2765 SD1 HD1 as is. Representatives Hashem and Sayama are excused. A no vote for Representative Shimizu. Any additional no votes? with reservations for Representative Cochran. Any additional reservations?
Reservations.
Reservations for Representative Garcia. Recommendation is adopted.
Thank you. Senate Bill 888, Senate Draft 2, House Draft 1, relating to consumer protection. On this measure, the only change I'm going to recommend, well, I want to do technical amendments for clarity, consistency, and style. But we have to modify the definition of operator on page 4, lines 9 to 12 slightly, so that it's more accurate. So operator means a person who develops, makes available, or operates a smart household security device to the public, and who collects, retains, or controls access to smart household security device data associated with a user account or profile. So that way operator does not include a retail store solely because the retail store provides access to or sells a smart household security device. So those are my recommended changes. Questions or concerns? If not,
Chair.
yes, Rep. Shimizu.
I'm gonna be voting with reservations. I wish the AG would have chimed in on this, but I'm gonna appreciate the BCCA's testimony and move it forward with reservations.
Okay, other comments? If not, Vice Chair for the vote.
Voting on SB 888 SD2 HD1 with amendments. Representatives Hashem and Sayama are excused. Are there any voting no? With reservations for Representative Shimizu. Any additional reservations?
Cochran.
Reservations for Representative Cochran.
Reservations.
Reservations for Representative Garcia. Recommendation is adopted.
Thank you. Final measure, Senate Bill 3001, Senate Draft 2, House Draft 2, relating to artificial intelligence. I'd like to move this forward with the recommended amendments from the Attorney General in their testimony. And also the amendments recommended in Department of Commerce and Consumer Affairs. Their amendment, which they have on page 2 of their testimony, making an amendment on page 2, lines 20 to 21. Those are my recommended amendments. Questions or concerns, members?
Chair, I always appreciate your thoughtfulness. I wish you had referred this so we had more time to consider some of the other amendments that was offered by industry participants that I think are greatly affected, whether it was ESA, Google, so forth, but I will be voting yes with reservations to move it forward.
Thank you. Other comments? If not, Vice Chair for the vote.
Voting on SB 3001 SD2 HD2 with amendments. Representatives Hashem and Sayama are excused. Are there any voting no? With reservations for Representative Shimizu. Any additional reservations?
Cochran.
Reservations for Representatives Garcia and Cochran. Recommendation is adopted.
Thank you very much. There being no further business before our committee today, we are adjourned.